May I be permitted to mention for upgradation of item number 820?
Upgradation, please come on Monday.
I beg to mention,
Date is on 29th, my lord. Date is
Maybe.
on 20.
my lord,
Yes.
beg to mention item number 63 and 64. My lord will kindly recall that my previous adjournment petition before the trial court was rejected. My lord was pleased to direct.
Yes, please wait. Let me see how far I can proceed. Yes.
My lord, kindly at 2 p.m. My lord, to be mentioned for release, my lord. For release, my lord.
To be mentioned.
May I seek your lordships kindly will also item number 900. I'll indicate why I'm.
For upgradation, please come on Monday.
I'll just indicate your lordship Tuesday. This is a trust property. Tuesday. your
Whatever it
lordship,
is, please come on Monday. There is an
One-
indication in the list.
One new motion, my lord. Actually, matter appeared on Friday. Passover was prayed for, but since there was resolution from 2 p.m., your lordship pleased to adjourn the matter. 25th is the date for argument, and I'm challenging the order rejecting PW1, recalling of PW1, my lord. Kindly take it up any day prior to 25, my lord.
And over this.
My suit was dismissed under a Section 8 application under the Arbitration Conciliation
What
Act.
you want upgradation?
My lord, it's not in the list, my lord, not in the monthly list also. My lord.
Addition, please come on Monday.
Appearing at 63 and 64, my lord, my two
Mr. Banerjee, let me see how.
Your lordship had heard this. Release chahiye.
Hand over the slip.
I permit to mention an option for extension of interim order.
Please hand over the slip.
Correction and extension of interim order.
Corrections, please hand over the slip.
Died, my lord.
45, my lord. I'm not seeking arbitration matter. I'm being led for Bhattacharya in this matter. I am for the opposite party on KVM. Only I'm saying is for some difficulty today and tomorrow. If the matter can be taken up.
Let me see. You are for the opposite party. Let me see when the petitioner comes. Please mention.
I understand they are online, my lord. I'm told they are.
Yes.
My petitioner died, my lord. Item number 1435. I filed sufficient application, my lord. Only one order died sent for
You want upgradation?
not my
This-
lord. For only one order.
Maybe. Come on Monday. Yes, call the list. Excuse me, please hand over the slip. Yes.
One blood, I am for correction blood.
Correction.
Department is not.
It চলছে না। বলছে Passover because it has been said that there is some typographical error. Let me see. Yes.
19. No, in this one. After that. But on the other 8 order. 8. Into order 6 weeks.
It has been pointed out that in the first page of the order, such and such, other portions of the order shall remain unaltered. Yes, call the next matter. Appearance is will appear. Yes.
That I appear for the opposite party.
Yes.
Take an instruction when I've read the petition. But the only request as of now is to meet the male child on his
On
birthday.
his birthday.
On his birthday. But he stays with the mother, with my client. But in Sri Rampur, the petitioner stays in Andaman.
Stays at?
Andaman.
I'm a
He's a judicial officer posted in Andaman.
Yes.
But I have no difficulty in letting the child meet the father. I can't have any issue. Only issue is the child stays with me all the time. Child has various ailments, which has already an admitted
No,
fact.
for the present,
Yes,
the
Milord.
immediate prayer is that on his birthday,
On
he will
his
be.
birthday,
Only on birthday, Milord, few hours I want to spend with
Please suggest the time.
Milord. Time, Milord.
What is the age of the child?
Milord,
4
according
years.
to them,
It's,
any
he will attain
independent
4
place-
years. He
4
will
years.
attain 4 years.
What
Yeah.
would be the convenient time on the birthday?
But I'll tell my lord, what my instruction is. But the petitioner has asked for 2 hours time, although in the petition, he has asked for 3 hours on that day. But the petitioner wants to meet the child, spend time with the child at a neutral place. But my suggestion was, I stay in my parental home. But
All right,
he
please
can
suggest a
come.
neutral place. Please suggest the time.
But I'll take instruction. I'll suggest the time. But a neutral place, my instruction is, the child, my client is not willing to let go of the child, spend time alone with the father. She wants to be there. Let the father spend time with the child. I have also advised her not to interfere when the.
What is the neutral place? Please suggest come with a. I shall take it up at 12.
At any
12,
restaurant.
please agree to a place. Please agree to a time. Come back 12. Yes.
Grateful. Yeah.
Next. Yes. Extension of interim order.
Yes.
What is the impugned order?
Your Lordship is pleased to pass an order on 16th April 2025.
Have you served the other side?
Yes, Judge Mukherjee appeared. My lord, he's received.
No, have you served the notice prior to mentioning for extension? Mr. Ghosh, what can be done? Not today. Next.
It may be
This is the minimum that is expected, Mr. Ghosh. Yes, call the next matter.
it may be appeared on one day, my lord. Tomorrow I will not be available.
That I do not know. You should have served. If you can bring the other side, yes, I can take it up. Otherwise,
I'm for the opposite party in the.
Petitioner, I have served the copy.
My lord, I have no objection if the prayer of the main revisional application is allowed, my lord. Let the matter be disposed of. I have no objection if the.
only that the application is liable to be. What was the application which was dismissed?
My lord, their recalling application was turned down. They have come up before your lordship. I have no objection. I am ready to face the.
Technical ground, my lord. They have diffused, my lord.
I have no objection, my
All
lord.
right. So I'm setting aside this order.
Sitting aside the order, my lord. I have no objection, my lord. Kindly one indulgence, my lord.
So PW1.
PW1, that is.
PW1, he will cross-examine.
They will cross-examine. I am the petitioner husband before the trial court.
Yes.
Must kindly give one date so that the cross may be conducted by a.
What is the next date? What is the next date?
My lord, I am not aware of the.
What not one day?
Huh?
How many days you want?
No. Court con.
Yes, what is the next date fixed?
Next date, 21st.
21st of
Tomorrow-
August.
August.
21st of August.
21st.
All right. So, Ashun. There is a can stands in view of the order. Pass.
Still some interim order, but difficulty is, my brief has been misplaced, my lord. That's why, my lord, I have unable to place every bit of service, my lord. Interim order was granted, my lord, on 1st September, my lord. My lord, 7-2 or 7-1 and 7.
You have not served.
My lord, my learned friend has said, my lord, service has been affected, my lord, entire brief has been misplaced, my lord.
The learned advocate appearing for the petition.
Include as sub notice, my lord, others.
You have served notice. Yes, what is the main matter, Mr. Ghosh?
Lordship, please should grant a stay of operation of the order. Lord, petitioner, defendant was directed to uninstall or dismantle the electric meter.
Mr. Ghosh.
Plaintiff.
Opposite party landlord.
Plaintiff, my lord, yes.
Lord, kindly fix it.
Yes.
Kindly fix a day for hearing of this application, revision application, my lord. Kindly fix a day for hearing of the revision application. So the matter may be.
My lord, by the impugned order, my lord, I had filed a section 151 application for a direction upon the tenant to uninstall a pump which they have illegally installed in the tenanted premises in the kitchen. By the order, it was allowed. Challenging that, my lord, they have come up before this honorable court. My lord,
Only source of water.
because of that,
Only there is no other.
my lord, they have a water
So that
KMC.
I can get water from this.
Kindly sees the impugned order, my lord. They already have a pipeline with KMC pipeline. Now, without taking the landlord's consent, without taking any permission from anyone, my lord, they have installed a pump.
What is the stage of the suit?
Lord, that point of time.
Suit is proceeding.
Suit is proceeding.
What is the stage of the suit?
But that instructions I don't have, my lord. No notice was served, my lord. I just found out today, my lord. I'm coming.
No notice was served.
Oh, my lord.
Mr. Ghosh, what have you done?
I have requested, my lord, on the earlier date also, I requested Mr. Ghosh.
Why are you
to
not
serve a
serving notice?
But if I am directed to uninstall or dismantle the water supply, my lord, I will be deprived from getting water. There is no other source of water.
All right. When do you want? I'm extending the interim order. The interim order is extended.
Nine, my lord. Mr. Tarok Kumar Haldar is appearing on behalf of the opposite party. What is nine?
Yes. It's an assigned matter.
Not assigned. Assigned. It
Assigned.
was extended before Justice Rai.
A lot. That is the applications under Article 220
Oh, no, sorry.
arising of the dismissal of the suit. The
Section 6
decreeing of
my
the
lord.
section 6 of the Special Act was filed by my learned friend's client.
Oh,
Section
that
3
was
allowed,
Decree.
decrease.
Against that, you have filed a civil revision application. It is to be heard, Mr. Haldar.
Well,
Just like an appeal hearing.
since
There is no
2000
provision for appeal, that's why civil revision.
since 2020, my lord, I am out of position. Running business, my lord, this is a
the-
saloon, my lord, without
in-
paying a
the
single
interim-
funding. My lord, for the time being, my lord, I am maybe secret, my lord, he is running business.
No, no.
This is a saloon business, my lord. He is running business without paying single funding since 2020.
I'm not a tenant. that
Sir,
I'm
let him
issuing a decree.
put him on terms, my lord. It is my lord, only bread and butter of me, my lord. I am out of position for last 6 years.
See the plain averments. He handed over the key to the petitioner for carrying out the business. That doesn't mean that he have been dispossessed from the issued premises.
Mr. Haldar, the order is of for status quo. You have not filed any application for execution.
Uh,
Order is of status quo with regard to the possession. No order of stay of execution or operation of the interim order. That's
Anyhow,
the
my
order passed.
that tantamount to my lord staying of the execution proceedings. Kindly
The
give me
interim
liberty,
order is
kindly
extended.
give me liberty, my lord, to pay for appropriate.
Liberty is not necessary. You are at liberty to file any application. Upon hearing the learned advocate.
I am appealing on behalf of the assigned order your lordship will not conclude the hearing of the petitioner. Only
We have
the
concluded,
part,
it's recorded in the
parties
order dated.
already.
It has been
22nd
assigned.
Yes.
My lord, this is that matter where we have challenged an award passed by the Madhya Pradesh MSME Council. Mr. Sabyasachi Chaudhary was leading me. We have concluded, my lord. My learned friend is to reply. And the interim order is expiring at the end of this month. We have also put in, my lord, the awarded sum
Kindly remember
with the court, my lord, that is with the
award
registrar.
passed by the MSB Council, Madhya Pradesh.
He has filed a
There are-
supplementary, my lord, that has been taken on record.
This matter has
Pray that the interim order may be made till disposal. I'll indicate your lordship why.
my
On
lord, I am
22nd
opposing
April,
that
when I
till
sir, let me complete. On
Yes.
22nd April, my lord, when I concluded the arguments, your lordship was inclined to grant me the interim order till the disposal because my learned friend was to reply the week later. But this hasn't happened, my lord. So all I'm requesting, I've put in the awarded amount also with this one, my lord. Let me be protected, my lord, till the disposal.
yes, yes. Next, call the next matter. Call the next matter. Next. Yes, call the next matter.
disposal of the title appeal.
Title appeal, what is the stage of the appeal? Who
Lord,
are you in the appeal?
Lord, the appeal is pending, still pending.
Who are you in the appeal?
I am the respondent, plaintiff respondent.
Plaintiff respondent.
Yes.
This application under Article 2. Huh?
Lordship. It is on evidence stage, Your Lordship. The suit is pending.
You are sure there will be no resolution of the bar on the next date? Then
Lordship,
you will take a decision not to attend and come up for expeditious hearing.
Lordship, the suit is pending since
Maybe.
2015. I am out of.
How many resolutions of the bar in the meantime? From the institution 2015 till date? Have you calculated how many dates there were resolution?
Lordship will kindly give.
This application under Article 227 of the Constitution.
My lord, I have instructions to appear on behalf of 3 of the opposite parties.
Yes, yes. What is this matter?
Well, in this matter, my lord, I am challenging, my lord, the order passed by the learned trial judge, my lord, where my injunction application was rejected, my lord.
How a civil division is maintainable?
Appealable order.
It's an appellable order.
Appealable.
None appears for none appears for the petition.
Behalf of the petitioner,
Your Lordship, I am for the respondent.
I am only seeking an adjournment, Your Lordship, because on the ground that there was a caveat, Your Lordship, and the caveator,
On
was
the
not
ground
served.
that,
On the ground that there was a caveat, Your Lordship.
yes, yes,
Your Lordship, last night we received the actually summon, Your
yes, yes.
Lordship.
What is,
led
but
by-
what is there in the?
Your Lordship, I'm
order?
praying
Please
for
proceed.
adjournment, Your Lordship. I'm
Yes, please proceed. Yes.
Lordship, the matter pertains to matrimonial suit that was filed, Your Lordship, under the heading of title suit. Thereafter, the learned
Lordship.
court below had passed an order for an ad interim maintenance of rupees 10,000 per month, Your Lordship. Thereafter, what happened was the wife filed several proceedings throughout the course under 498A of IPC, the Dowry Prohibition Act, DV Act. Several cases were filed. Thereafter, in the domestic violence case, they had also acquired an order of ad interim maintenance of 32,000 per month.
Your Lordship, may I?
Madam, please wait.
Okay.
Yes.
Now, what happened is, Lordship, under the DV Act, we have been paying. We had paid around 65,000, Your Lordship, till date. We are only seeking a stay on the order of the
By this order, what has been done?
Lordship, ad interim maintenance was paid for. Ad interim maintenance of rupees 10,000. This was passed in the year 2022, Your Lordship.
No, no. By the order dated 16th of June, 2026,
Lordship,
what
they
has
had
been
filed-
done?
They had filed an execution case
Yes.
for claiming the arrears.
And what direction was passed?
Lordship, that the arrears be given effective immediately, and therefore all the challans are.
But directed to file the challans. Please produce the challans. Then the court will decide.
Lordship,
What's there? Please show, produce the challans.
Lordship, there are multiple proceedings of claiming maintenance, Your Lordship, against me.
That's neither here nor there. If there is an order, you have to challenge that. Unless the order is set aside, that order remains in force. By this order, only you have been directed to produce the receipts that you are complying. Please produce the receipt. This application under Article Give her a copy. Heard the learned advocate for the opposite
In
point
the
of.
course of the day, I'll search.
Yes, yes. The learned advocate for the petitioner is directed to
Lordship, for the petitioner.
yes.
Yes, Lordship, I'm praying for the admission hearing. And this present revision application is under Article 227 of the Constitution of India and challenges the order dated 14/5/2026 passed by the learned civil judge, Senior Division, Sri Rampur, entitled suit number 117 of 2022, rejecting the petitioner's application under Rule 7, Rule 11 CPC. My submissions are very
no,
brief,
you are
Lordship.
challenging the
Government
order
authorities
dated.
have been
Madam, you are challenging the order dated 14th of May 2026.
14/5/2026, yes.
Yes, by that order, what has been done?
The order was actually we have filed an application under Rule 7, Rule 11, Order 7 of Rule 11 CPC, and that was rejected by the learned civil court.
No, please place the order dated 14th of May 2026.
It was placed, Lordship.
Madam, only your date has been fixed for service returns. There is nothing recorded in the order that your application under Order 7 Rule 11 has been rejected. Where is that? Please read out the order. Have you found out the order?
Yes, Lordship.
Please read out loudly. Madam, are you ready or you are not ready?
I'm just searching for the order, Lordship.
Is that the certified copy, madam, at the last? That's the last document.
Yes, yes.
I can read it out for you. Today is fixed for service returns. Both side files Hajira. No SR has yet been received to 15th of September 2026 for SR. Where is your application has been rejected? Ashun, this application under Article 227 of the Constitution of India is directed against an order dated 14th.
My lord, I appear on behalf of the petitioner. Lord, I am
Yes.
the plaintiff petitioner, my lord, in a suit for.
What is the order under challenge?
My lord, I am only praying for expeditious disposal of the pending applications, my lord. Kindly, my lord, takes up the certified copy, my lord, 6th of May 2026 order, my lord.
6th of
May.
expeditious disposal, Mr. Mondol. This is the volume. Sixth of
May, my lord. 6th of May 2026.
Yes.
It speaks for hearing on the point of acceptance of WS and issue of limitation, filing of the written objection in respect to application dated such and such. Hajira filed on behalf of the plaintiff, defendant number 124, defendant number 5, defendant number 6, respectively, through their learned advocate. Apparently, on 29th of November 2021, defendant number 124 of the instant suit filed an application under section 10. Apparently, on 22nd September 2025, an application has been preferred under 151 of CPC on behalf of defendant number 1 and 2 of title suit such and such with a prayer for.
What happened to that application?
Those are all pending. These applications are pending. Lord, yesterday was the next date fixed, my lord. Yesterday, my lord, the defendant took adjournment on the ground that they will be filing the
How many plaintiffs are there?
plaintiffs, my lord, 2.
What are the names of the plaintiffs?
My lord, page 19, my lord.
Page 19, yes.
My lord,
Progressive Service and
Happy
Happy.
Mascom Private Limited.
Where is Ashok Kumar Jain? How did you find Ashok Kumar Jain as plaintiff?
Maybe given.
De facto respondent. My goodness. What have you done? You have not checked up before moving.
But liberty may be given to my lord.
Mr. Mondol, honored advocate. Yes.
Lordship, this is regarding a succession matter, Lordship, wherein an injunction application was filed by the petitioner's sister of the deceased, Lordship, for an order of status quo, Lordship, in respect of 2 bank accounts of the deceased, Lordship. Matter was admitted, Lordship, but was passed, rejected ex parte, Lordship, against the nominee and other 2 legal heirs, Lordship. My humble submission is, Lordship, let the order of status quo, Lordship, till disposal of the injunction application, because, Lordship, nominee can at any time withdraw amount, Lordship. This is my more difficulty, Lordship. Nominee, Lordship.
Who is the objector in that proceeding?
Objector is the nominee and 2 other legal heirs, Lordship, but they have not entered their appearances.
What is the status of the nominee?
Nominee is nominee is simply a nominee, Lordship.
What is the status?
Status is just as nominee of the deceased, Lordship, in those accounts, Lordship, in those 2 accounts.
Where is the application under 151?
Lordship, page, Lordship. Yes. Page, Lordship, 28.
28.
Lordship. Being annexed as C, Lordship. Prayer portion, page 32, Lordship.
What is the name of the nominee?
Pratima Sarkar, Lordship. He is presently OP number 3, or opposite party number 3 in this in civil division, Lordship. Till disposal of the injunction application, Lordship, let there be an order of status quo in those respects of 2 accounts. This is my only prayer, Lordship. Page 33 is the schedule amount.
She is the wife.
Not wife, Lordship. That's why I have annexed 2 documents, Lordship.
The hearing.
There is a Lordship.
She is the wife. No.
She is not the wife, Lordship. I annexed 2 documents.
Maybe. Let the trial court decide on that.
Lordship,
no injunction on that.
Lordship, status quo.
Your own application says. Lordship. That's your own application says.
No, she is misrepresenting as wife.
All right. So, misrepresentation cannot be decided without hearing the other side.
So that is why I am praying for status quo.
No status quo without hearing.
Lordship, tomorrow also she can take away the money, Lordship.
Maybe you know the law.
Lordship, till disposal of the
nominee, if he or she takes the money and he's or she is not entitled to, you know the recourses. What's the law?
Money is disbursed, Lordship. Just I am praying for an order of status quo till disposal of the injunction.
No, not without any service. If you want a copy upon the other side of the ad interim injunction because you have been directed to serve. Please comply with that. If you comply with that, I can direct the learned trial judge to take up the hearing on 17th of September. That much I can do.
17th of September. Only status quo till next date, Lordship. Till next date.
No. I do not know what is the status quo. If she is the wife, she will not be allowed to operate the bank account.
She is herself, Lordship. She is herself saying, Lordship. Annexed deed, Lordship. Wherein she said she is wife of someone.
Either I have to direct you to serve, let the other side come and hear.
Yes, Lordship.
Or
order of stay of the
no, sir. That I will not pass. Without any interim order, 2 options. Either I will direct you to serve this upon the other side and I will hear this, or I will relegate you to the trial judge. I think that's better, with a direction that on 17th it will be taken up.
But Lordship, today also, tomorrow also, Lordship, the memory
if she is the wife.
She is not the wife, Lordship. Page 33, Lordship.
That's your statement.
No. Registered deed, Lordship. Registered deed. Kindly takes up, Lordship. Registered deed, Lordship.
What registered deed?
Page 68, Lordship. Registered deed. Kindly see page 68. A registered deed of conveyance, Lordship. Srimati Pratima Sarkar, wife of Amit Das. Kindly see, daughter of Satyaranjan Sarkar. That is why I am my humble submission, Lordship.
Yes.
Page 68, Lordship. Kindly see, stop.
Page 31, your application.
No,
I am on your application itself.
Lordship.
More interested, the same Pratibha Noshkar has purchased the property being flat number such and such,
Lordship.
being registered by representing herself as the wife of Sri Gautam Chatterjee and daughter of such and such.
Next paragraph, this is 2014.
Yes.
2018 deed, Lordship. Next paragraph, kindly.
Yes.
Kindly, Lordship. Next paragraph.
Sir, without hearing the other side, no injunction will be passed.
2014, she represented herself, wife of Gautam Chatterjee. 2018, Lordship, she represented Amit Das.
Then I will have to make observations on merits. Then, if you insist on the interim order, then I will have to record reasons why I am refusing the interim order. You can pray, but I will then have to decide that.
Subsequent one, in subsequent ones, yes.
That's open. If you are insisting, yes, you can make, you can.
I'm just, innocuous prayer, lordship.
That's not an innocuous. Status quo without indicating what is the status. I do not know what is the status of the bank accounts, in whose name, what are the bank accounts.
Schedule amount I am given, lordship. Schedule amount in page 37, lordship. Kindly see.
Page
Page
37.
17 of the of this petition. Page 17.
Yes, yes.
Page 17.
Yes.
It is in the name of the deceased. Page 17, lordship.
Yes. Page 17.
Of this petition. Page 17.
Yes.
Kindly see schedule amount.
This savings bank account is in the joint name or in the.
No, in the single name, lordship. In the single name of the deceased.
If these accounts are either of survivor, if it's a joint.
Single name, lordship.
That's one thing.
Yes, sir.
Second is, you have not mentioned that's in the single name.
Single name.
Second is, if there is a nominee, it's the bank's obligation to pay it to the nominee. Now, if you argue, you can argue on that. Then I have to.
Prayer for limited stay, lordship.
Oh. So if you have to argue, you can argue, because the nominee is entitled to receive. If her name is in the nominee, he or she is entitled to receive the money. And so far as those institutions are concerned, their obligation will go, because they have to pay to the nominee.
I follow you, lordship, but if
you follow, then why are you pressing for that?
just limited prayer for stay, lordship.
Again, you are praying. Then I shall have to record.
No, I leave it to lordship. I leave it.
This application.
Lordship. It's good for eviction on the ground of building, rebuilding, and my lord, the reasonable requirement. My lord, that suit was filed in 2023.
So decreed.
Suit decreed in 2026. My lord, it has decreed on my lord.
Then vacate, Mr. Mahato.
My lord, I have filed the appeal. I have filed the appeal.
Dilapidated house, why are you staying there?
Huh?
Dilapidated house, why are you staying there?
No, it is not dilapidated.
Good house. So what should be the occupation charges then, Mr. Mahato?
My it is now it is 8,500.
So good house cannot be 8,000. 8,500 is the rent. What should be what is the market rate?
No, my lord, what is the impugned order here?
At least 10 times. You have said it's not a dilapidated house. It's a in very good condition. That's your admission, Mr. Mahato.
But I have not given breathing time to get order of stay of in the appeal.
That breathing
Well,
time,
at the time of
I will give you time to breathe. But provided you also give something for the landlord to breathe. Yes. What?
Well, that I have to take instruction. That I have to take instruction. What will be the actual fair rent? My lord, I shall take instruction. Certainly, it has to be paid, my lord. Since the decree has been passed, my lord, it has to be paid. I can't deny that.
When the decree was passed?
My lord, decree was passed on, my lord, 12th of March 2026. My lord, I filed the appeal.
12th of March 2026?
Yes, I
So
filed
according
the
to
appeal.
you, 8,500 is the rent?
My lord.
Monthly rent?
Their claim also.
All right. So from March, April, May, June, July, August, 5 months. Deposit 50,000. Lump sum. 50 or 60,000 lump sum. I'm passing the stay for a limited period. I will hear the appeal. Hear the civil division application.
60,000.
60 because you have said 8,500.
Yes.
I've made it 10,000 without their side. I will direct you to deposit a lump sum amount without any quantification that can be decided after the. Ashun, what is the next?
27th of August.
27th of August. In the appeal court?
Yes, ma'am. Page 17. Page 17, my lord will get that. My lord, despite caveat has been lodged by the decree holder, my lord, the service return direction of service upon the other side has been given. And my lord, the matter is delayed. When I filed the put-up application, court has not received that.
There is section 5.
Yes. 93 days delay. 93 days delay.
Unless the section 5 is allowed, Mr. Mahato.
Even if, my lord, during pendency of the section 5 application, stay can be granted. This is not unknown, my lord.
Order 41, Rule 3, capital A.
My lord, even during pendency of the section 5 application, stay can be granted. It is not unknown.
There are contra judgments.
That's always there. If decision matter, there is contrary judgment. But it can be done.
This application under Article 227 Yes.
I am for the petitioner, my lord.
Yes.
I am for the petitioner subtenant, my lord. My lord, they have filed an application under Order 22 rule substitution application. Without
Order 22,
Rule 5.
Rule 5.
Or they have filed a substitution application, page 51, my lord, kindly see. Or 22 Rule 10.
51. Order 22, Rule 10.
Rule 10, my lord.
What happened to that? Allowed.
That application was allowed without considering they have the
Appellable order, sir.
no. With section, my section 10 was also rejected.
What section 10?
I have filed a section 10 application challenging that there are 2 suits pending. Well, kindly see the impugned order.
What are you challenging? Are you challenging Order 22, Rule 10 allowing order?
No.
You are not
Section-
challenging that.
Section 10. Well,
Section 10, all right.
31st
Section 10.
31st July 2026. Section 10 application and recalling application, both were rejected.
Recalling of what?
Recalling of substitution application. No,
But
by a
if the
common-
recalling of the that is what I am saying.
I am challenging.
If the recalling is rejected, that means you have to challenge the parent order. Parent order is an appellable order.
But section 10 was also dismissed.
You choose which one. If both cannot be done.
Section
Order
10.
22, Rule 10, then you are not pressing your challenge under good to you. Order 22, Rule 10. I will record that then.
My lord.
All right. Section 10, yes, now come up. What is the matter?
My lord, the petitioner is the subtenant, my lord. My lord, an appeal before the Honorable High Court at Calcutta. My lord, this matter in section 10, my lord, previously it was
Section
rejected.
10, it has not been disposed of.
No, my lord, it was kindly see the impugned order.
Order dated?
Order dated, my lord, 31st July 2026.
31st July.
It is further ordered that the petition by the defendant number 5 under section 10 of the CPC stands rejected.
It is further ordered?
That the petition under it is further ordered that the petition filed by the defendant number 5 under section 10 of the CPC stands rejected. Well, the impugned page 30, last page of the impugned order.
What is the ground of your stay?
My lord, initially, my lord, section 10 was rejected. My lord, against that, my lord,
Section 10, what is the ground?
2 suits, 2 ejectment suit for recovery of possession between the same parties on the same subject matter. That has not been considered, my lord. Kindly see the 2 suits I have annexed, my lord.
Both are pending.
Both are pending, my lord. Both are pending. Both are pending.
What is the number of both the suits?
Yes. First is ejectment suit number 486 of 2001. That I have at page 14.
486 of?
2001.
Where is the order sheet of that?
Order sheet, my lord, I have annexed. This is the
No, of 2001 suit.
2001 suit, my lord, I have not annexed, my lord.
Why?
So that is pending, my lord. 486 of 2001. That is pending, my lord. Even my lord granted a leave, my lord. My lord, kindly see page 44, my lord, once come. My lord's order.
That suit stood abated. What are you saying?
No, suit not abated. That is my specific point.
Please obtain the copies.
My lord, that is my specific
Have
point.
you produced any document to show that it has not abated?
Yes.
Where is that?
My lord, they said that the
Please produce the order sheets of that suit. Please produce the order sheets of that suit. The learned advocate appearing for the
On the port land, there is a huge slum
Portland, there is a huge club.
of more than 500 families. They've been staying for years together. Slum, not club.
Yes. Then what? No. We take first portion.
Appears, my lord, when the water supply was stopped, electricity connection was disconnected, then we came to know that there was a proceeding.
PP Act. PP Act.
PP Act against two individuals. And there's an order. Coming to know of that, we approached the appellate authority. According to me, wrongly advised. Because the order which was passed, it should be confined to the parties, it cannot be not in rem. Anyway.
No, you are not a party.
No, I was not. But when this disconnection was made, water supply was stopped, naturally we were affected. We come to know there's
Where is the order of the estate officer?
Estate officer order, my lord, I do not have the copy.
What are you challenging?
I am kindly come to estate officer at page 33, order of the estate officer.
Page 33.
Yes, which my lord was kind enough to ask. Kindly come to the order dated 23rd of February 2026 on order number 8. May I just read out? The matter is taken
Mr. Dotto, there is a courtroom in Shama Prasad Mukherjee Port, Kolkata. Courtroom. Please see page 33.
That's the way it's described.
Page 33,
Yes,
left hand top. Just after that caption, estate officer.
Courtroom at so and so. Fast or fairly placed.
There's a courtroom.
I have no idea, Milord. Maybe it resembles a courtroom.
Since they are authorized to pass order, they thought that it's a court and nothing else. Now kindly come to the order, Milord, at page 35.
Yes, 28th of February 2026.
Yes.
So here it was passed against.
This is against Milord one Mr. Hafizul
and Tarkina
Bibi.
And others.
And other unauthorized occupants and their family members who are unlawfully occupying. The party was specifically these two individuals, not the others of the party. And then also will not kindly come to Milord the.
Then this eviction order has been passed.
Yes. And the eviction order was passed, Milord. We come to know when Milord the.
So you prefer an appeal under section 9?
Yes. We now coming to know that this is an order which is affecting. We will not have approached the appellate authority. Naturally, we are time barred because under the Act, we will not 12 days time. And we take out an application in section 5.
What is the delay?
Total delay so far, we are concerned 106 days.
106.
But from the date of knowledge, there is no delay.
All right. So
now we applied and we also not prayed for stay. The
stay rejected on the ground that the section 5 pending.
That's the ground.
Yes, Mr. Dotto, what do you say?
The Supreme Court has, can you have a look to the order under revision?
Order under revision, yes. The order dated 13th of August 2026.
18th of August.
Page 35.
Order number 5.
Order number?
Page 35. No, it's not.
No, page 35.
Sorry, that is the essence of the order. Page 146.
146. Oh, the order is in the. I thought the last page is the latest order. No, 18th of August is the last order.
Yes.
Yes, this is under
challenging this.
Yes. This is under challenge.
No interim order of stay may be passed. Because section 5 is pending. Mr. Dotto, will not the party be remediless? One line of argument may be that unless section 5 is allowed, there is no appeal in the eye of law. So unless there is an appeal in the eye of law, so no interim protection can be granted. That's one part. Other thing is rightly or wrongly, there has been a delay. He has approached the court. During pendency of this, if the interim order is not passed, let us consider 1 day delay also there maybe for sufficient ground. Let us take a hypothetical case, not this case. 12 days is the period of limitation. On the 13th day, it has been filed. Even then, they have to take out an application that has to be condoned. And in the meantime, if on that logic, stay is not passed, even for a limited period, will not the party be remediless, Mr. Dotto?
Miller, two things, Miller. First is, Miller, the Supreme Court's view on, Miller, considering delay applications, Miller, under the PP Act, because Section 5 doesn't apply. The principles of Section 5 is inapplicable. Number one. Number two is, Miller, Supreme Court says that, Miller, the condonation jurisdiction in PP matters is a jurisdiction of reluctance. This is the Supreme Court's, Miller.
So that may be. Mr. Dotto, that may be, according to you, this ought to have been rejected.
Yes.
But till that decision comes, till that consideration is made, prior to that, and let us take that it's an exceptional case where the court finds no, it is to be allowed. In a hypothetical case.
Yes, the exceptional case again is a Miller expression which is not used in the statute. The statute, please have a look to the statute once, Miller. Please take me out Section 9.
Yes.
Miller, kindly take, Miller, the Section 9(2). I skip over, Miller, the main part. Please take the proviso in 9(2). Provided that the appellate officer may entertain an appeal in exceptional cases after the expiry of the period, if he is satisfied for reasons to be recorded in writing that there was compelling reasons which prevented. The
Sufficient was substituted by compelling reasons.
Compelling reasons and exceptional cases.
Yes.
It's not an exceptional circumstance.
Yes, it's the same thing.
Yes,
Exception
possibly
case.
not. Possibly not. Subject to correction.
No, that's on merit, Mr. Dotto. That's on merit. According to you, you may say that the case made out in Section 5 or the delay condonation application, whatever, or extension of time, whatever way you look at, that does not deserve or merit allowing that. That's one way. That's on merit.
Could I say this, Miller? There has to be a difference between an exceptional circumstances and an exceptional case. Why? Exceptional circumstances is certain factors relating to a situation, whereas the exceptional case is the gravity of the subject matter. That is why, Miller, the legislature chose exceptional cases instead of exceptional circumstances and compelling reasons. Now, all these, Miller, came from, Miller, that S.S. Bandi's judgment. Please have a look to that. 2013, volume 12, Supreme Court cases 631.
Those directions part,
yes,
guidelines part.
Yes. Paragraph 33, please take only one. 33.17.
33.17.
Yes. The liberty of the appellate officer to condone the delay in filing the appeal under Section 9 of the Act should be exercised very reluctantly, and it should be an exceptional practice and not a general rule. Miller, otherwise, Miller, while taking up, Miller, the condonation applications, whether it is under Section 5 or under any other
according
statute,
to you, in a way, while deciding Section 5, the view is, one line of judgment is that a liberal view to be taken. Court should see in some cases if it's a meritorious appeal, yes, please condone the delay. According to you, these principles may not apply here.
Will not apply because Bandi followed by the amendment.
Yes, but those are on merits.
Yes. Now,
one thing that
please take the application, which is it is wrongly nomenclated, but I don't.
Can I take 5 minutes of?
Yes, sorry. I was very restrictively submitting is that, my lord, number one, the principles of, my lord, the other litigation, statutes regarding condonation of delay doesn't apply, number one. Number two, as fell from your lordship, my lord, the general rule is that if the appeal is otherwise meritorious, why look into the delay part, irrespective of the.
That is in section 5. Those are, those line of judgments are in section 5. So according to you, it's a stricter view here.
Yes.
The language of the statute is such that a strict view is to be taken. It's not as liberal as in section 5.
Despite, my lord, so many judgments, my lord, or in the field that the court should ordinarily be very liberal in respect of condonation of matters. Now,
yes.
these amendments are 2013 onwards. This is number two. Number three is this exceptional case. Then exceptional case doesn't mean that I was prevented for XYZ reasons or exceptional circumstances, somebody did XYZ. That will not apply. The subject matter must be so grave.
But Mr. Dotto, that stage is yet to reach now.
Now, kindly, my lord, have a look to, my lord, their so-called Section 5 application.
So,
What is
Mr.
said?
Dotto, can I go into the merits of that? Because the appellate court has not considered that on merits. Any observation from my end on the merits might not be appropriate, because merits to be decided. You may have a very good case there. You may say no, and their application might be rejected also.
Yes.
That's on merit. But my question to you is, during the period for which it's pending consideration,
Section 5, whatever it is.
or extension application, whatever it might be. So during consideration, should an interim protection be granted or not? That's the issue here.
Because the matter is fixed on 7th of September.
For hearing of the appeal. And the stay application has been...
No, for the condonation of delay, application for condonation of delay.
Sorry.
Please check the last line.
Application for condonation. Yes, 7th of September.
May I take one instruction?
Of September is not that far away.
But the difficulty is,
So if one thing, stay application is
there is
otherwise
no stay
ready.
application. There is no
Or
stay
this application for condonation. Sorry, not
No,
the
no,
stay
no.
application.
No.
Yes, first order is stay refused. First order is stay refused. Mr.
But
Datta, only one thing.
Kindly
Have
see
you
where the third paragraph here in the first page.
circumstances this code is no interim order of stay may be passed.
No
Two
separate
paragraphs.
application for stay has been made by the appellate. That is wrong.
No, sir, an interim order stay of may be granted, otherwise the purpose, no, whatever it might be. Now we are concerned with this condonation part or the extension. Have you put in your objection there?
No.
So because you have to put in your objection.
Oh, yes, I have given. Sorry.
You have put in your objection.
It's on record, page 73.
All right. So if you have put in your objection, I direct the appellate court to take up on that date. Till that time, I'm granting protection. So if it's rejected, then it goes. Stay goes. If it is favorable, the appellate court will consider the prayer for stay if they have filed. If not filed, it's
It will be done on merit, that's all.
because pending consideration, Mr. Dotto, if a person cannot be rendered remediless, Mr. Bhattacharya's client may say, yes, I have filed, please hear it today.
Yes.
I don't need any interim protection, please hear it today. Please decide my application and please decide my stay. You know
the problem is, my lord, they feign ignorance today. There were paper publication. there was, my lord, the
All these may be a very good ground on merits. Their application may be rejected. That is why I'm not commenting on the merits. I record your submission that it's a stricter view, language, everything. But I cannot comment on the merits. I cannot from here say that Mr. Bhattacharya's client has made out a very good case,
No, no, certainly
or
not. Yes.
Either way, I cannot say. So I'm leaving that issue open. I'm passing a limited order till 7th. Mr. Bhattacharya, if you have not filed stay application, then it's you have filed.
That is also similar.
Then Mr. Dotto, have you filed any objection to the stay? Then on that day, I will direct both to be taken up.
তো জজ সাহেব তো রেকর্ড করেছে স্টে অ্যাপ্লিকেশন ফাইল হবে আপনি অবজেকশন দিলেন কি?
If not, you can file your written objection to that.
But kindly not observe anything on that. Fix this on, my lord, 7th and kindly direct disposal of the condonation application on that day itself without any adjournment. Kindly do this at least. Because the problem I'll tell you, lordship, is
there are two things, Mr. Dotto. If assuming condonation is allowed, then again, if the stay is not taken up, provided stay is there, application is there, stay application is there, then again another round here. Because the court will say, you will say, yes, there is no stay, I can proceed. So best is Mr. Bhattacharya is saying that I filed an application for stay. You put in your objection. If a condonation rejects, there is no question of stay. If the condonation is allowed, then both of you will be hard on merits because you will be then saying that conditions to be imposed. If Mr. Bhattacharya succeeds in the first step, then conditions, those are also to be taken into consideration. So why are you, because you are interested in expeditious disposal of the appeal. So let these interlocutory applications be disposed of one way or the other. If you have not put in your objection, file it, because 7th you will be getting some time within
before 7th I file my
you file your
objection
written
to the stay.
To the stay, and section 5 objection you have said that you have filed. So I direct the condonation to be taken up first. I direct the condonation to be taken up first. Subject to the result, the other applications, whether it will be taken up, the court will consider that.
Well, my client now instructs me that I think this is a wrong recording, that against the stay we have filed our objection also.
I will record. If not filed, you will be entitled to file written objection. Because what Mr. Bhattacharya is saying, let the section 5 be allowed. That Mr. Dotto cannot agree to that.
No, something else.
This application under Article 227
facts that Mr. Bhattacharya submitted, that after disconnection, that should be corrected, madam. That after attempt was made, the appeal was preferred. That
After attempt was
Yes.
made, thereafter the appeal was filed. তাহলে item number?
I was supposed to take instruction.
Oh, yes, that matter.
Yes, the venue and the time has been agreed upon. The husband
Please
will.
put the venue in a piece of paper.
Veto restaurant at 12. Veto restaurant.
12
noon.
Please put the time and
I-
venue in the piece of paper.
12 noon, there's a restaurant right across the Srirampur court that we have agreed.
From both the
Yes.
fathers this place.
If both of you have agreed upon, I did
yes,
not say
agreed.
whatever.
Only one thing, the father should come alone and I shall also bring my child. There will be no other person. There are apprehensions. That is why I'm. Lordship may record that in the.
Yes, yes. This application under Call the next matter. Yes, 22.
I am for the caveat of opposite party.
Sorry, appellant petitioner, but in a proceeding under section
218(3).
appeal has been preferred. In that case, I am for the appellant. I filed one application for local investigation.
Please use the microphone.
I have filed one application.
Please adjust it.
I have filed one application for local investigation that has been rejected. Only on the ground that
In an
delay
appeal under 218(3), where is the scope to file order 26 rule 9?
to ascertain, my lord, only that thing that whether
Mr. Das, an order of demolition.
it is deemed to be a suit. That appeal, my lord, therefore provision
No,
is
sir.
that
It's not a suit.
no, that provision
It's
is
not
there
a suit.
before the learned civil code.
Maybe.
Section 218(3.
Maybe it's before a civil code, but all provisions of the civil procedure code will not apply to that.
Then what? Then how can I prove my case?
That's
because report of the BLRO, my lord, I have challenged the appeal. Can you see?
Well, show me the order of demolition passed, which is under challenge in 218 subsection 3. Please show me that.
Page 15, 1-5.
From the middle portion, my lord, I am reading.
14 start, my lord, 15 order.
Today, at the time of hearing, Mr. Such and Such appeared before us and submitted a field verification report of the plot in question, sent by the BLRO, which shows there is a 6 foot wide concrete road throughout the plot number 100 towards the southern side, which is a part of the said tank, and that means tank of the bank was already converted into concrete pathway. The report further says that there are Pakka houses of Raju Manna, Nimal Shah, Rajesh Manna constructed over the tank, and no permission were ever taken from any authority. Since it is a settled law that nobody can be allowed to construct over the tank water body, therefore we are of the view that the aforesaid construction raised by the appellant Raju Manna and respondent such and such raised over the tank in question are highly illegal and not permissible. This is the report I have challenged, my lord, in the appeal. Your lordship will kindly see, because this
So this report, where is that report?
Report, my lord,
I have. Malad, prior to that, Malad, kindly come. Malad, on the ground of suppression and misleading statement, Malad, his appeal must go. Malad, kindly comes to page 20. Paragraph 5, his contention is that construction is making in the Pukur Park, that is plot number 100.
Under Abbas Jojana,
Yes.
municipality, my lord, granted me permission to raise that construction.
Yes.
Already construction was there. It was in a dilapidated condition. I got the permission.
Sir, Das, please, he is submitting. I will come back to you. Yes, Southern Embankment with the consent of.
Malad, that is, his case is that construction is made on the bank of the pond as a plot number 100. Now, Malad, under the scheme, now kindly see in which plot, Malad, he got this sanction. POI scheme. This is the RTI report, plot number 90 and 40. 99 and 104. No, Malad, any sanction under the POI scheme, Malad, on plot number 100.
Malad, that report.
And Malad, that is the. And Malad, this is the report of the Malad, the RI.
Yes.
But kindly see page 23.
So thus I will come back to you. Let me see.
And another case, Malad, my learned senior says that he purchased bank of the pond. Malad, I have collected the deed of the Raju Manna, from where, Malad, my lord will find.
Yes.
Well, your lordship will kindly see page 23. Page 20, that is in the appeal. Last, I'm not reading the entire paragraph. Your lordship will kindly see last fifth line, last 3 or 4 lines. Further, the BLRO made a report without proper inquiry and submitted the report to the Diamond Harbour municipality. And based on the report, Diamond Harbour municipality on such and such directed your appellant to notice by notice, serving notice upon your appellant to remove your appellant house within a period of 3 months. Then your lordship will kindly see page 24, that is the grounds. For that, the municipal authority, without making an inquiry and on the basis of the expertise report filed by the BLRO, passed the order dated such and such and sub notice on your appellant dated, which is illegal and liable to be caused. But now your lordship will kindly see what is my point for local investigation, that is page 30. What is the point? Court says it will make delay. Kindly see page 30. The points for local investigation. Municipal report, I have also challenged in the page 25 that your appellant only hearth and home is situated over the embankment of the pond and not over the water body. So the impugn order dated such and such and serve notice illegal and void. Then your lordship para D, that your appellant states that if your appellant build his house with the assistance of the approval of the municipality by complying with all the requirements under PMYAG scheme and with the supervision of Diamond Harbour municipality over 1 decimal of land, which is clearly embankment on the pond and not over the body, to so the notice dated 9 September 24 served by the respondent municipality to your appellant is illegal, void and liable to be caused for the interest of justice. Therefore, the entire order, including the report, has been challenged. That is yet to be adjudicated.
On which dag you have made a construction?
Upon the sanction plan, my lord, that
Which dag? Which dag?
100, embankment of the 100.
100.
My lord, this is the point.
Show me your plan on 100.
That was submitted before the authority.
You must be having a copy
At
of
present,
that.
in not with me. And kindly see, my lord, what was the point? Page 30.
30.
30.
Yes.
Well, the investigation commissioner is conduct and relay the plot number 100 and to ascertain the existing construction of the appellant is falling within the water body or not. Investigation commissioner is to ascertain the measurement of the construction of the appellant which is falling within the water body, if any. Investigation commissioner is to draw and submit a sketch map. Now your lordship will kindly see the order impugned. Upon submission of the plan, my lord, I am the beneficiary under this Abbas Yojana, and municipality granted me permission. They are saying that I have raised construction of the water body. To ascertain, my lord, this fact, this investigation is necessary. Kindly see the order impugned. Considering the above discussed points, it prima facie appears that error plot number 100 is pukur.
Which page? Which page?
Order impugned, the last page.
Last page.
Before
yes,
considering the above discussed point, it prima facie appears that error plot number 100 is pukur, upon which the appellant has his house. Accordingly, if the prayer of the appellant for appointing local investigation for survey of the error plot number 100, then it will create unnecessary delay in the proceeding of this case and without any fruitful result. Accordingly, the petition is rejected. Therefore, this is to be adjudicated. Whether I'm saying it is part of this bank. Plot number 100. They are saying in plot number 100. And the report, which has been shown just now by my learned friend, that report is under challenge in the appeal.
Kindly to the
In the appeal itself is the
second
ground.
page, second page of the impugned order.
Yes.
This is a submission.
Hard and considered, thereafter the learned court's finding. Perusing the materials on record, it can be pointed out that as per the purchase deed by virtue of which appellant, namely Raju Malla, acquired title 1 sotak of land out of 15 sotak of LR plot number 100, clearly transparent that it is a pond in nature. Apart from that, it can also be traced out that after going through the copy of the sanction plan on the basis of which appellant claimed that he constructed his house upon the land in question, that is LR plot number 100 is an embankment of the pond, is incorrect. Moreover, the sanction plan clearly depicts that it was sanctioned by the Diamond Harbour municipality for construction of a single-storey residential building for the appellant or Raju Malla on LR plot number 99 and 104. I have handed over for my lords that document. Under Khutian number 683, Mouja Sachan Saja, not LR plot number 100. Next paragraph. Again, the plot information of LR plot number 100 with Mouja such and such reflects the nature of the land is Pukur and 1 Sotok of land. Such Pukur has been recorded in the Rebon Rajumonna. The letter dated such and such which is given to the given by the Rajumonna addressing to the BLNL Diamond Harbor reveals that the appellant applied for conversion is 1 Sotok of land within LR plot number 100. It is clearly implies that the nature of the land is Pukur water body for which appellant apply for conversion.
Well,
And
I'm
Malad,
denying that. I'm
now,
denying
Malad,
that
kindly,
for that investigation.
Malad, kindly see his deed also. Malad, that deed in the schedule, Malad, kindly see.
Malad, I'm denying that.
One decimal,
Investigation, Malad.
one decimal, no Malad, the Pukur part. And this is one of the record of rights of in respect of 100.
100 is Pukur, but there is no denial of that. But I have raised concerns the embankment of the pond, and they are denying, my lord. Therefore, this is to be ascertained.
This application under Article 2
appear for the opposite party, my lord. We have not been served, my lord. Maybe come back after service. But I'm making a request, my lord. Can come back.
My lord, matter is relating to the, my lord, the 151 application filed by the defendant financer, which has been, my lord, allowed by the trial court. And they have been asked for the section 5 and 8 of the Arbitration Conciliation Act of 1996. My lord, the financer already, my lord, possession of the vehicle, my lord, before the filing of the suit. I have challenged the suit, my lord, kindly come to the prayer. I have challenged the suit on the legality of the loan agreement. They have filed an application on the 151, thereafter filed an application, my lord, the under section 5 and 8 of the Arbitration and Conciliation Act.
There's an arbitration clause.
There was an arbitration clause, but this suit is not, my lord, related with the, my lord, the commercial
Show me the
vehicle.
plain.
The kindly see the come to the plain.
Yes.
Page, my lord, the starts from page 13, pair of the plaintiff. Declaration to the effect that the plaintiff is entitled to and return the possession of the said vehicle bearing number such and such from the defendant, and the defendant or their men have no right to forcibly seize the said suit vehicle except by due process of law. Permanent injunction restraining the defendant.
Yes. So, is it a dispute? Because there's admittedly, there's an arbitration agreement.
My lord,
But this arbitration, my lord, kindly appreciate, they have filed a section 21 application, my lord, petition before the we served the notice. My lord, section 21, my lord, the petition notice, my lord, they have not stated in the envelope which has been annexed.
That's a different thing altogether.
My
The
lord.
suit has to be referred. If there's an arbitration clause, and this is a dispute with regard to a property which was purchased with loan.
No, this
loan
is the vehicle in question.
Yes, yes.
The vehicle in question, my lord,
was purchased with loan, and there's an arbitration clause.
my lord, they are up to, my lord, kindly appreciate one thing, my lord, we have challenged the suit for the irregularities. We have pleaded in the plain, not in connection with this, my lord, the
This
dispute
vehicle is
regarding
not the subject matter of loan.
no, subject matter of the loan.
My lord,
Kindly
I-
come to the page 5, pleadings from the paragraph.
My
5
lord,
of the-
kindly seize the impugned order once, my lord. I have the impugned order, my lord.
Please let him submit. You are saying you are paying for an adjournment, that you have not got a copy, and you have started arguing. This shows that you are ready.
Oh, my lord, I just wanted to show, my lord, because certain submissions
Let
were
him
being made.
submit. I will come back to you. Yes.
My lord, they have been, my lord, the only, my lord, they have taken by the possession of the vehicle, my lord.
Defendant that the installments included insurance premium, loan would be granted. RBI is represented that blank, signed, printed.
Yes.
These are all.
These are all another point is, my lord, that
You have
they
not
been
paid for cancellation of that agreement.
cancellation, but we have challenged the, my lord, loan, my lord, they have been asked for, my lord,
Loan.
they have been
Did you pay
agreement.
the amount directly to the from the to the company from where you purchased?
No.
Then who gave it to you? You do
I
not
have-
know. Blank paper. They have signed.
My lord,
All these are
my lord,
known.
all these, my lord, they have been, my lord, colored.
Fraud. The issue of fraud also can be looked into by the arbitrator. Those are the recent judgments.
My lord, fraud has to look into the, they have been passed the expertise arbitration. We expertise arbitration by the Chennai. I have annexed a copy of
That's
the
a
award.
different thing. I'm not on that.
By
Here-
kindly come to the page 80.
Here is whether your suit is to be referred to the arbitration or not. I'm only on that.
My lord, this suit, my lord, they have been, we have filed an application order 41 rule 1 for the vacating, for the return of the vehicle. They have been, my lord, using the vehicle, my lord, paying the EMI
cannot
some
decide-
other person.
Sir, I cannot decide that. It's a question of reference only. After reference, you go there. Make all
They have
payers.
been concluded the proceeding, my lord, the arbitration, my lord,
Make
the
all payers
expertise
there.
expertise award has been
Application
passed.
under Article 227 of the Constitution.
Just that is my.
Yes, what do you want to submit?
My lord, just the impugned order, my lord. 22nd June 2026, I believe, my lord.
Yes,
My
yes,
lord,
yes.
kindly
Which
post.
portion you are trying to rely upon?
My lord, learned lawyer for the plaintiff, my lord, that is the fifth paragraph from the top.
Yes.
Learned lawyer for the plaintiff in his usual fairness submits that in view of the agreement for arbitration dated 22nd April 2024, containing resolution of dispute to the arbitrator as per clause 44, he has got no objection, provided the propounder, that is the defendant, submits certified copy of the loan agreement dated 22nd April 2024. My lord, there is an admission on record.
This application under Article. This application under Article Yes. Yes, call the next matter. Nahi, ঠিক আছে।
In this matter, Somiron Giri for the petitioner, he
2
is
PM.
No, my lord, not today, my lord.
Why?
He is go for treatment for his eye, my lord.
24, not today. Next.
Number 25, I'm praying for not this week.
Why?
Not landed advocate on record is not.
Come at 2 PM.
my lord, on my behalf, Mr. Senior Advocate Mr. Debasis Rai pay for time while I was in Disha Eye Hospital for my eye checkup. But now I have come, your lordship can take up the matter or as your lordship desire.
24.
Yes.
There is any caveat?
No, there is no caveat.
Yes.
But it is very short matter. But the point is whether the execution case is maintainable or not. Because
Whether what is
whether
maintainable?
the execution case is maintainable or not. The suit for declaration permanent injunction. And my lord, the suit was dismissed. Against that, appeal filed. Appeal court, my lord, the plaintiff made an application for amendment for recovery position. But that recovery of position application was allowed. But against the defendant, prefer revisional application here. My lord Justice Banerjee, Sanjeev Kumar Banerjee, his lordship then was, rejected the amendment application. And my lord, the appeal court declared the right title interest and permanent injunction. And removal of the school building. A very sensitive issue is, my lord, the school is a government school. Government not a party here. But the plaintiff degree holder put the degree into execution for obtaining the recovery of position. How is it, my lord? I am asking myself, how is it maintainable? So, my lord, your lordship kindly see the impugned order. Impugned order, my lord, the learned court come to a conclusion of delaying the matter. You are trying to delay the matter and not to execution proceeding should be continued. That is why when I come before your lordship, that application, section 47 application was rejected. I come before your lordship on that ground, my lord. Well, kindly see 150, volume 2, 150.
Please
Yes.
give me a minute. Yes, where is the decree?
My degree, my lord, your lordship kindly see. But that was not annexed, but I have given the copy. Right, the government school, your lordship kindly remember, my lord. Government school, government fund, government teacher. Without any recovery of possession, they are now trying to demolish this. The school situated in the year 1910, before independence. And school building is, my lord, maximum portion, large portion in the vested land. But they are now trying to correct the record of rights without implementing the collector, BLRO, SDLRO, because they are the custodian of the property. And as your lordship knows, as and when the regarding the correction of record of rights, the BLRO should be made parties. I being the head teacher of the said school, I have contested this matter. I have taken the point. The school is defective, not maintainable on the ground of non-joiner of party, because the state government has given the aid to construct the building. And my lord, the degree, there is no plot number mentioned. Which plot? There is my Khelar Mart and pond and other common room.
This construction was made pursuant to a permission granted by the court.
Appeal court.
Where is that permission? Please show me that.
Yes, my lord.
Where is that permission to make construction? Where is that order?
My lord, kindly see the order. So this order is not with me, madam.
So admittedly, that permission was granted with an undertaking that you will demolish the same if the order is against you.
Yes.
Yes. Now, how can you take this plea, Mr. Giri?
Your lordship kindly see.
Now you cannot take this plea, Mr. Giri.
Yes.
Up to second appeal, thereafter review, you have lost. These points were taken and decided.
In a very technical manner. Because
Everything is technical. Suit, first appeal, second appeal, everything is technical.
My lord, your lordship can pass the order. I am bowed down, my lord, your lord. For one thing, as in when my lord the review application dismissed on the ground, your lordship knows. I personally moved this matter on the review application rejected on the ground. I have not taken the no objection from the legal advocate who moved the order for one application. On that ground, the application was rejected. But my lord, the essential and necessary parties should be made party, because I am the headmaster. If I demolish the same, then government can ask me, yes, how you have demolished the same. Then they will take in the Department of State, suspension, everything, my lord. So, my lord, your lordship can give me opportunity to serve the copy, and they will come for essential. This is one important law. For essential to protect the government school. Your lordship can see the your lordship can see 173.
Page?
Can you see 173? Page number 173. This is the school building. Your lordship, kindly see.
What shall I do with the photographs, Mr. Giri?
No. This is the sketch map. This sketch map.
Shall I-
My lord, entire 348.
Mr. Giri,
wasted land.
you are permitted to make construction pursuant to an order passed by the court with an undertaking to demolish. End of the matter.
Yes, but my lord,
You know where you sought for permission, where you have constructed, so demolition,
my lord,
everything.
subject to correction. The school building in the wasted land. Your lordship, kindly see.
Whatever it is, vested land, not vested land, these points cannot be reopened now.
No. My lord, kindly see again, my lord. 170. Your lordship, kindly see 170. My lord, 170 is the record of rights.
Mr. Giri, I cannot go into that factual aspect.
So, my lord,
In execution 47, I cannot go into
No.
that.
if your lordship pass the order, then my lord, academic session will be chaos.
That
And my lord, the student will be.
That is for you. You should not have continued. You should not have continued the academic session. You know the fate.
No.
It's up to you. You know
Yes,
best how to.
my lord, I am agree with your lordship, but if some protection act.
You have taken that risk. You have to face the children and their guardians.
Examination is going on. Till
That's-
December, your lordship, I mean.
No. That's neither here nor.
Correction.
After December, then the Madhyamik examination will come. After that, you will again start an academic
My lord,
session.
it's a primary school, your lordship, give me chance. Then my lord, your lordship, give me.
File an undertaking that you will demolish.
Yes.
Are you ready to give an undertaking?
Yes, next day.
Please bring the undertaking, then I will admit this.
Very well, my lord. Then, my lord, Monday, headmaster will come. My lord, who will give undertaking?
That's it.
Then, my lord,
Mr. Giri did not give any undertaking.
Give. On Monday, my lord.
No. Who will give the undertaking that you do not know?
No, my head teacher. My your lordship, kindly give
Then
me
you
the-
take the point that the head teacher has been changed.
No. He is the permanent.
Ashun, this
My lord, I have
application.
to have- Hold that hand, my lord. Give me chance Monday. I'll give you the undertaking. Your lordship, give me chance. Now your lordship ask me undertaking. I'll give, my lord. Certainly, my lord.
Who will give the undertaking? That is the $1,000,000 question.
By Monday.
You also do not know who will give the undertaking. You have put that question.
Teacher, my lord, head teacher will give.
Head teacher may be transferred tomorrow. The new head teacher will come and say, no, I am not bound by the undertaking.
These are headmaster change. I am the present headmaster.
You may be changed day after tomorrow.
No, I am giving the, my lord.
Ashun,
Your
this
lordship,
application,
give me chance.
application under You said who will give that undertaking?
No,
After hearing
no, I am withdrawing the
Yes,
same. I
no,
am
no.
withdrawing the same.
Once you have, I have also withdrawn. Since you have
But
withdrawn, I have withdrawn. Yes,
from the
next.
bar, from the bar I have uttered.
Not today, করে দিচ্ছি, Monday থাকবে.
from
Yes,
the
next.
Like,
Undertaking,
to be
sir, Giri, unless they agree to that, there is no use of undertaking.
To be mentioned. Better be to be mentioned.
Same position, not to be mentioned. Yes, yes, who is appearing?
One thing subject to correction. Kindly protect the education. Right to Education Act, my lord.
But in item number 25, I'm praying for only not today. I've been told to pray before your lordship not to as the learned advocate.
What is this matter? What is this? What
But
are
I
you
don't
challenging?
have the brief. I have been instructed by the clerk of the learned advocate to pray for not today, my lord, only.
Not today means not this year. Be assured for that. Not today, I can grant you, but that will be not this year. Please move.
My lord, I don't have the brief, my lord, even. Kindly make it not today.
The issue that arises for consideration is please bring the Supreme Court judgments on this. Yes, next.
This application is challenging the impugned order passed by the learned trial court whereby the application filed by the father for rearrangement of the visitation right was rejected.
For?
Rearrangement of visitation right, my lord, filed by the father, it was rejected. My lord, the impugned order is at page 139.
139.
Yes, my lord.
You have not given the certified copy.
Yes, my lord, I have annexed the certified copy, my lord.
Certified copy cannot be paginated. What is the date of the order?
My lord, the order date is 15th May 26.
15th May 26. Yes.
My lord, my application was rejected without assigning any reason. My lord, in
How could you paginate this certified copy?
may I be granted leave to make necessary correction, my lord, if my lord permits. My lord, in 2025, your lordships passed an order giving liberty to the father meeting.
Where is the order dated 21st of May 2025?
21st of May.
No, which order you wanted modification?
My lord, I want modification of order dated 15th May of 2026. My lord, may I kindly permit to make some submission, my lord, on September
No, 15th
2025.
of May, your application for modification was rejected.
Yes, my lord.
What was the original order for which you wanted modification?
My lord, this is the original order, my lord, 15th of May 2026. By this order, my lord, my application was
Where is the order
rejected.
dated 11th of December 2024?
My lord, 11th of December is, my lord, starting at page 119.
119.
Yes, my lord. And my lord, the relevant portion is page at 120.
So you wanted modification of this order?
No, my lord. After this order was passed, I filed a civil revision in 2025, in which your lordship gives an order granting the father, allowing the father to meet the child once in a month for 3 hours and twice video call. My lord, and further granting liberty to both the parties to pray for before the trial court for modification of the order and also further arrangement. By virtue of that order, my lord, of September 2025, the father filed an application for modification of the visitation right, which is, my lord, at page 126. My lord, this application was filed before order passed by my lordship on September.
Where is the application for modification? Page?
Page 126, my lord.
126.
In this application, my lord, I have prayed for visitation for twice in a month for 5 hours each and video call 4 times a week. My lord, this application was rejected by impugned order dated 15th May 2026 without assigning any reason.
This application has been rejected by 15th of May 2026.
Yes, my lord. My lord, this application was filed on 21st of May 2025 and my lord's order was passed on September 2025. This application rejected. It was first and finally heard on 15th May 2026.
So now it has been modified that visitation will be on second Saturday of every month instead of third Saturday.
Yes, my lord. On the same date, on 15th of May, the mother filed application for modification of the order. Instead of third Saturday, it should be on second Saturday. There was extracurricular activities classes. My lord, her application has been rejected, allowed, whereas my application has been rejected where I have prayed for twice a month visit and 4 times video call.
Where is the petition dated 15th of May 2026?
My lord, that is at page 134.
Yes, so this application was allowed on consent.
Yes, my lord, I do not have any objection
So
with
if that
allowing
is
this.
allowed on consent,
My-
how the same order can again be modified?
My lord, I have no objection with the prayer of the wife, my lord. I have only challenged to the extent rejection
Cannot
of
be
the
done.
application,
If
my
that
lord.
application has been allowed on consent, that is the existing modification.
My lord,
If both were heard on the same day, again it cannot be modified. So the effect is, if one is allowed, other has to be rejected. And that you have given consent to that.
My lord, earlier, my lord, by your lordship.
Nothing will happen. You are
My lord,
meeting
kindly
the
allow
child
me
on, as per that, I'm directing the miscellaneous case to be disposed of.
My lord, kindly allow me for 1 minute, my lord. Why your lordship's order dated September 2025, your lordship allowed
After that, the wife has filed, mother has filed an application dated 15th of May 2026
Yes, my lord.
for modification. That application has been allowed on consent,
Yes, my lord.
modifying this order. So how can that again be modified?
My lord, instead of third Saturday, my lord, it was changed to second Saturday, my
That
lord.
you
I'm
have
seeking for
agreed.
twice a month.
You
basis,
should have
my lord.
at that point of time said, no, I'm not agreeable to that. I want this modification. Once you have agreed to that, meaning thereby you have accepted that prayer, given a go by to your application. Ashun, this application under Article 227 of Yes.
The defendants in a suit for partition will challenge the propriety of an order by which the application under Order 7, Rule 11 was rejected. Kindly seize the plain. The plain starts at page 12.
On what ground? Order 711?
I say
A, B, C, D.
Suit not maintainable because she has claimed ouster and she has not sought recovery of possession.
This matter was moved. Why it was adjourned on the last occasion?
Because the clock struck 4:30. Yes. Clock struck 4:30. Let's see. I'll confine my scrutiny only to the plaint. Kindly seize the plaint. Paragraph 9, 10, and 11 at page 15. The plaintiff admits that she is the owner of 12.5% of the suit property. That's paragraph 9 at page 15. The last two lines. Para 10, she says defendant number 1 is the undivided owner of 17/48, defendant number 2, 17/48, and the defendant number 3, 1/6. Then she says, paragraph 11, she alleges ouster. They forcefully oust the plaintiff from her in-laws house on such and such. Under compulsion, plaintiff moved to parents' house. So admitted ouster. Now, kindly seize the prayer at page 16. Does not seek recovery of possession. There's also an issue of ad valorem court fee, but for the present, I would not press that because that doesn't entail a dismissal or rejection of a plaint. It's only after the court asks them, the plaintiff, to pay the court fees and plaintiff doesn't, then a cause might arise. But for the present, so far ouster has been pleaded, number 1, and no recovery of possession has been sought for, the plaintiff is liable to be rejected.
Proviso to section 34.
Yes. He has to seek recovery of possession. Has to seek recovery of possession, being out of possession.
Please show me your application under Order 711.
It's there, it's there. Page 22. That kindly seize paragraphs 3 and 4. Specific. At page 23, paragraphs 3 and 4. Sure.
The issue that arises
Petitioner before your lordship is the husband, my lord. I am praying for expeditious disposal of a application for divorce on mutual consent. My lord,
Application for divorce on mutual consent.
my
What is the next date fixed for appearance?
13th of October. 13th of October 2026. Application
Yes,
is
you want
filed.
to prepone that date.
But on that day, my lord, may be disposed of because my lord, 3 dates have already passed, my lord.
Where is the difficulty if both the parties appear on that date?
My lord, they are staying, both are working at Bangalore and they have to come down to
Yes.
Calcutta, my lord. On
Why are you apprehending that it will not be taken up on 13th of October
My
2026?
lord, already 3 dates have passed, my lord. 10th December 25, 31st of March, the PO was on SIR duty.
SIR, what they can do?
5th of July, PO was on leave, my
No,
lord.
no.
Let it be disposed of on
When it was filed?
25th of September 2025.
Yes, 26th of September it was filed. So 6 months takes us to March. So March that date was fixed. March they were busy with the SIR duty. So it was adjourned on
July.
4th July. The presiding officer was on leave. And 13th of October 2026.
They have to come
If
down.
there is a resolution of the Bar Association, what you will do?
That is difficult to say. My lord, will kindly direct on that date, my lord, it may be disposed of, my lord.
If there is a resolution,
That case, my lord, if the parties appear, my lord.
Ashok. Yes.
So I am praying for not today.
Don't pray for not today. Yes. What is this? What is this matter? What have you challenged?
That's right.
The learned advocate appearing for the petitioner may be just. Yes, next.
That I am for the opposite party number 1 and 2.
The other opposite party.
And I am taking the point of maintainability.
Yes.
If, my lord, an order whereby, my lord, section 17 order application was disposed. My lord, as of today, the date is to the tune of rupees 24 crore. My lord, obviously, my lord, to avoid the pre-deposit, this application has been filed. So, my lord, I want to, my lord, take the point of maintainability first before my learned friend. Before my learned friend, my lord.
The order under section 17.
Yes, 17 application disposed of by passing a reason order.
This side. Mr. Bhattacharya, that side is heavier.
Who said so?
You are alone.
He is Prabhu.
Nobody is siding with you. You are also in this matter.
Alternative remedy.
Yes. It's an appellable order, Mr. Bhattacharya.
Wait for us. Let us.
Now this side is more heavier.
Let us begin.
Will not prefer an appeal. Why?
The subsequent
Let everyone make their submissions. They have the best case on earth. I have the worst case on earth. Mister, let me make my submission.
Yes, certainly.
Milord,
Two things can be
let me
considered.
make my submission. Milord, every point is against me. I want to satisfy your lordship how the order should be set aside and the entire issue should be remanded back there.
Where is the order? Where is the order?
Before that, may I take two points? One is preliminary point has been taken. This operator is available. Secondly, subsequent event took place. Already the possession has been taken in accordance with law, and it is with the purchaser.
And purchaser.
Certificate has been registered.
You are also there.
For another. He is for the probably purchaser. That
Sale certificate registered.
these three things has to be taken into consideration. Now, now let him submit.
He has not taken
Mr. Bhattacharya, then it used to be hard. There's no question of passing any interim order. I can keep this for hearing. Because it looking at the appearance of the advocates.
Don't see that. Subsequent event took place. That is my duty to.
Bhattacharya, there's no scope to pass any interim order. This will be hard. What's there?
Why not that? 50% of
Yes,
let
Mr.
Mr. Chatterjee say how much money he has put to get the auction. How much money he has put? Because he has taken that 14 crores.
14 crores.
He has taken that 14 crores. Lord,
But,
why are these submissions being made? I know I have a very, Lord, I have a very uphill task. I have a very uphill task, Lord. Let me.
No, Mr. Bhattacharya, there are two ways of looking at it. One is this an appellable order.
Yes.
So you have to go before the appellate tribunal. If you say no, I will move this. You put in the prerequisite that the 227 court can also direct.
But interim order he can pass. Okay,
That the court 227 court can also pass.
Alternative.
That can also pass. Put in this amount.
15 crores.
I will hear this.
Would it not be a lordship's gracious pleasure to at least look into the series of orders made by your lordship's court, which ultimately, Milord, gave shape to the judgment and orders delivered by the case. Would it not be your lordship's pleasure, Milord? This is not the first occasion that this matter is traveled to your lordship's court. There are at least 5 various orders which obliged the DRT to first decide certain issues. They have refrained from doing so. Thereafter,
Yes. Tommy.
Now, the first of the orders here is page 126.
126. Please show me the impugned order first.
Impugned order is,
Page
I'll just show.
or the certified copy.
Certified copy is here.
Certified copy,
So
yes.
that is that page, after the judgment, after 220.
Yes, 28 July 2026. Yes.
No, no. The order rejects my 70. Order rejects. Now, there are certain why I wanted to take your lordship first to page 126 and onwards. There are reasons. May I just, in my humble way, I know I have a very uphill task to cover. Please see page 126.
What I'm saying, my lord, is asked for any interim order?
I took leave from your lordship, saying that possession will be taken. The matter was appearing in your lordship's list on a particular day. When the bench, for some reason, it was not available. I went to the coordinate bench to mention the matter because the determination came a little later. The coordinate bench said that his lordship is not sitting only for a day. I'm not going to be disturbed. And the other side, my learned friends, all were there to oppose me as far as the mentioning. They were right. They were right. They were right. They were right.
Please, caution notice was
If
served
the
10 days back.
determination comes to us at 11 o'clock, if the determination comes to us at 11
Caution
o'clock,
notice was
if
served
we
10
come
days
to
back.
11 o'clock, we can't be held.
Waited till
When was the imprisonment passed? When did the go and mention?
Do I not have a right to carry the proceeding for 227? Perhaps there is no limitation. There is no limitation. We have come within the time earmarked at page 220. Please come to page 220 first. I am seeing the nature of opposition to justify the conduct of the bank who has parted away the entire property at a pittance.
What is RBC Act? You have taken loan, you have to pay back. This paraphernalia has, my lord, is coming into the play for our benefit, lawyer's benefit, nothing else.
So get benefited, sir. Let me make my submission. You have already been benefited.
You pay.
Try not to
please.
do all these things here. Please allow me to be. You have made your submissions. You have made your presence felt. You are a very senior person and I owe highest regards and respect towards you. Please don't say this.
If he is asking for an interim order, my lord.
Yes, I am. Because,
to roll the court back. Very good.
In the teeth of pendency, they have unnerved the entire situation. The CO was pending on a particular day. It was appearing in your lordship's list. Date of, I mentioned the matter, and the matter was fixed on the 12th. 13th was the date of possession. On the 13th, without even waiting for the outcome of the present proceeding, I have a worst case, they could have waited for 2 days.
10 days back, or notice was.
They could have. I put this question to myself, yes, there was no intent, but we were also not, sitting silent. We have been pestering, in fact, day before yesterday, at the time of rising, I indicated to your lordship, there's some urgency in the matter.
Again, behind the back. He wants to mention all the time, not at the time of mentioning.
Yes.
He will come up at 12 o'clock and stop.
Well, I don't need to be advised. The next matter was that matter, this matter.
So, Basu, please go that side. Let Mr. Chatterjee come this side.
So the next matter was the matter. Your
I have to look after that.
Up to 41 or 42, I wanted to bring it to your lordship's notice that there is some urgency. Nothing beyond. I did not want the matter to be taken up out of turn in the absence of my esteemed friends.
No, revisional application was not maintainable, my lord. Kindly see in the High Court Calcutta civil revisional jurisdiction appellate side. Is there any original side? On that ground, kindly don't hear it. On that ground itself, it should not be heard.
My short.
Somewhere has to be stopped this.
It's become an epidemic.
Mr. Basu.
And my lord will be saying that you are not doing anything.
Yes, you are responsible for that.
No, my lord is allowing it.
You are responsible.
I know, he is correct. I have pointed out in some cases, my lord.
Because
All of you agree?
Again, I am pointing
Yes.
it out.
From tomorrow, I will start that. Any defect, I will reject.
That's what used to happen. What
I
happened?
cannot say that, but can I caution them? What is this? What is
Strategy, Mr. Basu, for that. You are accepting that those briefs. You are moving that. You are not scolding them.
But after it is filing in the court, you have been briefed.
Something is to be done from your end also.
Those are not there. It is a chamber practice.
Will not do.
What can be
Both
done?
of you are senior advocates.
Oh, bole lab.
So, briefs are,
Well,
they are coming to
so
you.
long. Remember what happened, used to happen there. The advocates on record were not even scolded, but were taught as well. One matter your lordship teaches, the others won't do it. But nowadays your lordships are lenient.
Another thing, and nowadays, if any time my lord has checked the vocalatma for the opposite party, no, this sleeve, this papers has been kept here, and I am appearing. What happened? Subsequently, somebody says, no, I was not briefed him. It is my lord's fault. My lord is not checking this. And the remainder thing have with Mr.
If that is to be, if those things have to be verified,
We have to face that music.
if those things are to be verified, this supplementary list will turn into 50 pages.
Is it not
My determination only.
Is it not
I'm telling
necessary? My lord, if somebody says I am appearing and say something, my lord is rely on that. Subsequently, client said, no, I have not briefed him because vocalatma is not there. This happened in my case, one of my case.
Certified copy.
This
Your lordships are granting leave.
Sushaman Sengupta's case,
In one
5,
court,
6 matters.
when the matter comes up, and if the certified copy is not given, the entire matter is missing.
Yes. Yesterday, I have got one of those matters. Revision application filed 1 year back with leave. Now, yesterday also, till that date, certified copy was not filed. What can be done? Yes, Mr. Vadajaji.
So before a lordship hear him, can let him deposit. He is bypassing the appellate provision.
Mr. Basu, there is no absolute embargo. He wants to.
I am
He
not
wants to
saying-
come within that window.
I am borrowing my lord observation in another day where it says it more or less closed.
No, here, Mr. Basu, that is a different thing. That's under the Civil Procedure Code. Remedies under the Civil Procedure Code. There, the alternative remedy is.
That matter was not civil procedure, but my lord's observation was the Supreme Court in 227 in these cases says that it is not more or less closed. The court cannot say it is closed. That's why it is said more or less closed.
Mr. Vadajaji wants to come within that window, within that exceptional cases. Let him place his place. Yes. Yes, Mr. Vadajaji. Now, Mr. Vadajaji, only one thing, since this has been pointed out, heavy objections, you have to amend this appellate side, the cost title.
It is not there. Kindly sees they are looking at the zero for the first 2-3 pages, the synopsis, and kindly sees the stamps,
Oh.
that page. It is not
No,
there.
in my copy, it's not there.
It is also not there in my copy.
What I can do?
It is
Yes,
not-
Mr. Chatterjee. In my copy, it's not there.
Very good. Then he is exonerated for that.
No, but second volume is there.
Yes.
First volume is not there. Second volume it's there.
That is, will not just be carried, the volume petition.
Yes, that should not have been also done.
I take it. I take it on myself. It's my mistake.
Who is the advocate on record?
I take it on myself.
Please correct it. একদম উপরে লিখে দিন on the Yes.
If capable of valuation, he owes 25 crores.
Adding to valuation house.
That is matrimonial suit.
This is neither a matrimonial suit nor a trust suit
Yes, yes.
My lord, before the starts again, should we, my lord, point out those demurrer judgments for your lordship consideration, or is his lordship's mind?
All right, you can place so that he can meet with those preliminary objections. They are raising a preliminary objection, Mr. Bhattacharya.
And all judgments are against me, I'm telling.
So let them cite.
I'm telling your lordship, my lord, there is no.
Let them cite one or two decisions. You can cite. Don't multiply.
What, my lord, am I not entitled to persuade your lordship? My lord,
Mr. Basu, if you,
entitled to distinguish and persuade your lordship.
if you want
I'm just
to,
putting this question to myself.
if you want to cite any decision, don't multiply. Cite one or two decisions on that.
Krishnan paragraph is there.
A person who is going to be clout down by, my lord, all these things. I can't be cowed down by all these things.
I am between two friends, my lord. I am been.
He's my friend outside court. He's always my friend.
2001, you are citing. There are latest decisions, Mr. Basu.
Yes. Last chapter did
You have gone back to 2001.
It doesn't matter 2001 or 2006. এটা কত 10 এ 3 কেন 24 টা দে না
No, of course. But as against he pointed out the loan is 25.
This is that matter where my lord conditional undertaking was given and thereafter because the position was taken as there was a conditional undertaking. And thereafter, my lord, the
Here
matter
also,
was-
Malad, the same problem as the last matter. So Mr. Nag now is in the other side.
well, my lord, I have taken that. Now, my lord, here, before, my lord, on last occasion, my lord, the first thing, my lord, that the civil revision application we have challenged, my lord. While drafting this civil revisional application, we found well, the initiation of proceeding was itself well, without jurisdiction.
Yes, here is the appellate side.
Appellate side.
Yes.
And
Mr. Nag,
certified copy was given. Malad.
dismissing this. No, you are a party. You said that, yes. Judges are lenient.
Also, Malad, if the
It's
certified
not
copy
in form, I am.
whether the certified copy was given.
Certified copy is
No,
also not
I
given.
don't know.
I have taken leave.
Exactly.
I have taken leave.
Exactly.
Yes.
Exactly.
Have you applied for the certified copy?
Applied for.
When have you applied?
I will place that one. But I have
When have
taken
you
leave
applied?
and
And it dismisses it right now.
we have applied in on first. And well, I have mentioned that it was civil revisional application.
Yes. You have not yet obtained.
No, not yet. Not yet.
আমি KVA
Perhaps stood lapsed. Your application for certified copy stood lapsed.
I am yet to receive the
আরে অ্যাপ্লিকেশনটা তো দেখা তাহলেই তো হলো
Where is the application?
is not carrying it right now, but we have
Lord,
applied.
kindly vacates, kindly dismisses the, I tell you Lordship why they are doing this. What they've done is, after giving Milord an undertaking before the court that I will not proceed with the execution, after a period of time, they've gone Milord and taken Milord possession, saying that I've given it the undertaking at one stage. The court did not grant a stay because they gave an undertaking. And then went and Milord took possession. And now Milord, all my articles, well, it's a place where Milord, the medical instruments Milord are being dealt with. And they put a padlock on the entire thing. The court has said give back possession right now.
Yes, Mr. Nag. What is the order which you are challenging?
Yes, first, before going to the impugned order.
And Kylie sees the audacity now. The audacity of port choice, it's on a different level. Now they've floated a tender saying that they are going to auction that property. Looks to this. They think, Milord, courts are nothing, Milord, but rubber stamps.
What he is showing, I have.
This is your tender, not mine.
I have no knowledge,
Please see this, whether you have issued this or not.
Then I have to take instruction and come.
Please take instructions.
I have to take instruction.
Your officers might be here.
Relax. Please relax. It's unbelievable. They are state.
I have to take instruction.
Please take instructions, Mr. Nag. Your officers are here, I believe.
Phone call করতে হবে।
Please take instructions. Please take instructions whether this has been issued by you. And whether you are proceeding with this.
Can I come back tomorrow?
Not tomorrow, please take instructions. I'm passing it over. I will be taking out 4.
At 4.
Yes. Yes, call the next matter. Yes.
Reduction of exodus hearing order, my lord. Good. Earlier occasion, my lord, this petitioners came before lordship for
What are you challenging?
My lord, I'm not only seeking a direction for expeditious hearing, my lord.
Expeditious hearing of what?
Expeditious hearing of the suit.
Of the suit.
Suit
What is the
number-
stage of the suit?
Now, my lord, the deposition of the defendants are going on, my lord.
Cross-examination of the defendant number 1. This application under Article 220.
Item number 32, I am appearing for the petitioner plaintiff, my lord. In a title suit for partition, my two applications have been rejected by the same order, my lord. One application is filed under order 6 rule 17 and another one, my lord. under
Order 6 rule
section-
17 for what?
Yes, my lord. Order 6 rule 17 for the amendment of certain pleadings in the plaint. Under the circumstances when, my lord, the title suit is for the partition, my lord, and preliminary decree was passed in 2015, and thereafter, my lord, at the time of effecting partition by the learned advocate commissioner, my lord, subsequently discovered certain relevant amount of the portions which were not incorporated in the plaint. That is why the amendment was sought for. If your lordship kindly come at the impugn order. But I am reading the relevant portion of the portion from the impugn order. If your lordship kindly come at the paragraph number, my lord has got the impugn order.
Yes, yes.
Yes. My lord, it is in the middle of the portion that
it is pertinent to mention here that the preliminary decree has already been passed in favor of the plaintiff, while order dated such and such. Thereafter, my lord, on perusal of the petition dated such and such under order 6 rule 17, I find that the plaintiff has mentioned that he wants to delete certain properties as mentioned in the plaint and introduce other new properties. And the plaintiff now through amendment wants partition over 51.57 acres of the land instead of the 2.09 acre of the land. And he intends to delete the dark 25 and add dark 223. And the plaintiff has also mentioned new facts like 8.25 decimal of the land was transferred by way of the gift in that number 157, which was earlier mentioned through purchase, and now the ordering portion. Well, as such, the amendment shout for if allowed would totally change the nature and character of the suit property, and the reasoning is very interesting, my lord, as the entire physical characteristic and demography of the main suit gets altered. This is the only reasoning why the learned
What
civil
more is required? You are trying to change the entire thing.
no, my
schedule.
lord, it is the partitions.
After the preliminary degree, we have not challenged the preliminary degree.
No, my lord, not challenge.
So
my lord.
now it's the only
There is
the
no-
allotments that has to
There
be
is
made.
no absolute bar in permitting the subsequent preliminary decree can be passed.
Sir, what can be done now? The shares have been declared. You have not challenged that preliminary degree.
Yes, my lord. In this regard, I will rely upon the specific judgment passed
Yes.
by the Honorable Supreme Court, my lord.
Yes.
Will Lordship kindly take up it to them. Perhaps, my lord, my copy has been handed over to your lordship. My lord, kindly come at the page 10. I am relying on the paragraph 18 of the internal paragraph 7. And this has been derived from the judgment in called Fulchand and another versus Gopal Lal. May I read, my lord?
Please give me a minute.
Yes. Your Lordship, kindly come at page number 10, paragraph number 18. But I am reading the relevant portion where upon which I am relying upon. But my lord has got this. We are of the opinion that there is nothing in the Code of Civil Procedure which prohibits the passing of more than one preliminary decree if circumstances justify the same, and that it may be necessary to do so, particularly in partition suits when after the preliminary decree some parties die and shares of the other parties are hereby augmented. We have already said that it is not disputed that in the partition suits the court can do so even after the preliminary decree is passed. It would, in our opinion, be convenient to the court and advantageous to the parties, especially in a partition suits, to have disputed rights finally settled and specification of the shares in the preliminary decree and varied before a final decree is prepared. If this is done, there is a clear determination of the rights of the parties to the suit on the question in dispute, and we see no difficulty in holding that in such cases there is a decree deciding these disputed rights. If so, there is no reason why a second preliminary decree correcting the shares in a partition suit cannot be passed by a court. So far, therefore, as partition suits are concerned, we have no doubt that if an event transpires after the preliminary decree which necessitates a change in shares, the court can and should do so.
Yes. So facts is the different. After the preliminary decree, if the shares are changed.
Yes.
So after the preliminary decree, if there is a transfer and other things, then it can be. The facts of this case is, please kindly come to paragraph 21. The court may not have a suo motu power to amend a decree, but the same would not mean that the court cannot rectify a mistake. It's the court's mistake here. If a property was subject matter of pleadings and the court did not frame an issue, which it ought to have done, it can at a later stage, when pointed out, may amend the decree.
Yes, my lord.
So in this case, it was a case where in the pleadings, those properties were there. But there was a mistake on the part of the court that properties were not considered and the preliminary decree was passed.
Similarly, my lord, opposite circumstances.
Here you are trying to change it's not a circumstance change after the preliminary decree. You are now trying to assail the preliminary decree, change that property.
It has been passed in my favor, my lord.
Whatever this change is not after the changes not done after the preliminary decree. That's not your case.
Yes.
Then how does this decision help you?
If your lordship kindly consider that nothing has been changed, nothing likely changed to entirely change the nature and character of the property, because the suit is a partition title suit paying for the partition, my lord, and it remains
That cannot be
after the
reopened in
amendment
that
of the
way.
pleadings, my lord.
This decision is different on facts.
If I do not,
You are now trying to change the entire schedule. Wants to partition over instead of 2.09. He also intends to delete some of the darks to add some other dark. How can that be done? The property which was subject matter of a partition decree has been passed. Now you say, please delete that. Can you do so?
because my lord, it subsequently discovered that
No.
the relevant portion has been omitted mistakenly.
That cannot be done in this way. If you want time, I can give you time. You can get yourself.
Yes, my lord, I come back with the.
Yes. Not today. Yes. Next.
Great. Well, may I get back the copy?
Judgment.
Yes.
Judgment copy. Yes. 33. Yes.
33, my lord. My lord, I'm the wife in a matrimonial suit, my lord. I'm the wife in a matrimonial suit, my lord.
Yes.
My lord, cross-examination of PW1 was closed, my lord, due to, my lord, the fact
You are
that
the
my lord,
wife.
I'm the wife. Due to the fact, my lord, I have delayed for, my lord, 3 years for cross-examining the PW1. Now, my lord, kindly consider, my lord, one thing, my lord, in 2023 itself, my lord, I have filed a section 36 application for alimony. That was disposed of in the January 2026 itself, my lord. Thereafter, my lord, it is fact that I have prayed for time. But now, my lord, I have prayed for recalling of that order also. That was also turned down.
Lordship, I am for the opposite party husband. Lordship, I have instructed to appear on his behalf. Lordship, I have not filed caveat and all these things. Copy may be served
Copy.
and fix a date. Lordship will come back
Tomorrow?
tomorrow.
Fine. Grateful.
Is করতে হবে না, not to defer.
No.
Yes, next.
For the matter of the private respondent in an appeal under section 218.
Private respondent?
In an appeal under section 218(3) of the
Yes.
West Bengal Municipal Petitioner before your lordship. The complaint is, my lord, that the jurisdictional civil judge, the proceeded with the appeal, my lord, without following the direction issued by this Honorable High Court, my lord, in a earlier revisional application to expedite the appeal. My lord, your lordship, kindly take the list update for once, my lord. I will shortcut the matter, my lordship. The demolition order was passed in January 24, 2017. My lord, initially that was assailed by filing a writ application. My lord, writ application, my lord, the point was taken that the order of demolition was not supplied. Only the notice of self-demolition was supplied. That writ application, they failed to secure any interim order. The writ application was not pressed. Thereafter, my lord, another appeal was filed in 2017, my lord, challenging the notice of demolition. My lord, the appeal was admitted, that order was assailed before this honorable court. This honorable court held, my lord, the notice of appeal is not an appealable, my lord, the order of demolition is an appealable.
19th, the appeal is fixed.
Now, lordship, kindly take, my lord, your lordship, kindly take the order of this honorable court in last revisional application. Your lordship will take from page number 191, my lord, from page 180. Lordship, kindly come to page 181, the last paragraph. However, the proceeding should not be dragged only on the account of non-appearance of municipality.
Petitioner is directed to serve a copy of this
In this matter, my lord, the matter has already been become infactual. So I am not praying for withdrawal.
the learned advocate appearing for the petitioner That is why, being the landlord, you are challenging the 7172.
They have not filed it previously.
Then it has to be decided. It cannot proceed expeditiously. Because this goes to the root of the matter. Yes. Yes. Yes, where is Mr. Nag? Mr. Dott, where is he? Yes, Mr. Dotto, what is going on?
This is actually inadvertence. Kindly give us one data. Kindly keep it tomorrow.
Dotto, this should not be your attitude.
But I don't join.
Article 12 authority, you have taken, there is an order directing restoration, and you have issued this auction.
No excuses, nothing to justify. I will not do that also. Please take it tomorrow. Let me be like
No, let the matter be heard out today. This is a my problem. I on the last occasion I didn't say anything. My the entire property
On the
has
basis of
been
the matter,
seized by
with
them.
regard to this, yes. Yes.
আমার উপর মেডিকেল ইনস্ট্রুমেন্ট গুলো সব জজ সাহেব নেবেন না কাজ নেবেন
Please take it up tomorrow.
There's immense all medical even last occasion I didn't say anything. Medical instruments inside.
Last occasion he had some difficulty. He was on.
I had no difficulty. I was doing the matter online. They had no difficulty at all.
I calculate hope.
Can it be maybe in the morning?
Morning is difficult, Mr. Chatterjee.
Below, this is again
motions.
The lordship will dismiss it below because they don't have not even applied for certified copy. On that ground itself.
That is also one thing.
On that ground itself.
Leave is granted to file without the certified copy, considering the urgency, but he will not obtain the certified copy. He is saying he has lodged a caveat, he has applied for the certified copy, he has got, and you have not got.
Everything I'll check and come.
কালকে তো হবে।
আমার খুব চাপ অনেক
Tomorrow, Mr. Chatterjee, matters are fixed.
দেখলে kindly my lord
Wait, anytime tomorrow 5 minutes.
এটা certified
Morning, afternoon, before rising, any
তো তোর কেভিএট এটা
কালকে কোনটা আছে 3:30?
দেখুন না তিনটে ফিনটে কিছু একটা সময়
Only thing that Dr. Mr. Chatterjee are fixing these contested matters.
This is not
after
contested,
3 because
Milord.
to take up small matters in the morning. Otherwise,
Lord, kindly appreciates my problem. There is no
motions are get stuck up.
I'll tell you also what this matter the problem is. They have taken possession, put a below seal pack. I am going back to the trial court saying that look here, there is no stay. So here's out my police help application. They are coming up here showing there is a revision application. And my lord, it goes on forever. Now the problem is that inside that where they have locked it, my lord, are medical instruments. Forgets about my GST papers. This is a go down where my lord, all the hospitals are my lord, being given these medical instruments. না না আরে না রে আমি প্রভু হয়ে গেছি সারা দুপুর প্রভুকে যা জ্বালিয়েছে না তুমি চিন্তা করতে পারবে
Take
5 minutes 5-10 minutes not more.
তাহলে কালকে এটা 3:15 রেখে দিন। কালটা 3:30 আছে তো।
Tomorrow is a Friday.
Yes.
3টে ফ্রি আছে তো এই তো রেখে দাও 3টে 3টে করে দাও
ওটা হয়ে যাবে 15 মিনিটে। কোনটা আছে কোন ম্যাটারটা আছে?
আমি বড় সড়ো মামলা থাকি না তো এইসব ছোট মামলা থাকি
ছোট মামলা
হ্যাঁ ছোট মামলা থাকি
কটা আছে 3:30 3টে তো এটা 3:30 রেখে দিন perhaps that will not go on for long.
Keeps it at 3 then not at 3:30.
No, 3 matter is fixed. I'm fixing it at 3:15.
3:15
এটা 3:15 এ রেখে দিন কাল
3:30 হবে 10 মিনিট বলেছে আমি 2 মিনিট
when this matter is taken up for Yes,
My senior is engaged another court. My senior is engaged another.
you are here.
I'm-
Yes, yes,
I'm praying for adjourn for this week.
yes, yes. Let me see what is this.
That's why I'm not aware this matter.
What is your name?
Subrata Vairag. Subrata Vairag.
Yes.
Kindly adjourn.
Where is your senior?
Another.
Ask him to come. Pass over. Ask him to come. Yes, next.
38, my lord, I appear on behalf of the
Yes.
case of the land acquisition. The
Yes.
initially the award was made by the Learned LA collector.
Yes.
Subsequently, I preferred in an appeal. And there was an order in the appeal, my lord, and being agreed and dissatisfied with, I preferred an appeal before this honorable High Court, my lord.
Yes.
The operating part of this order is written in page 44, my lord.
What order you are challenging?
Now, there's a delay in payment in spite of your lordship's order. My lord, kindly see, the earlier occasion I moved the similar application before your lordship.
No.
Yeah. Problem is that, my lord, they have deposited the amount, but in the as per the honorable division bench order, there is a direction to pay the decretal amount.
Which order you are challenging? 16th of January 2026.
16th January, the last.
No, what is the infirmity in this order? Only a direction has been passed upon the state to recalculate the decretal dues and make a fresh decretal estimate. How are you aggrieved?
They are delaying the entire process.
Delaying 26th of March, what happened? 26th of March for filing fresh calculation sheet. What happened on that date?
Kindly see, there is an order, page 79. Kindly see that page 79. The lordship's order.
Yes, I passed an order directing these proceedings to be disposed of expeditiously. Now the state has been directed to file a decretal estimate. What happened on that date?
The intention of the state to dilute the issue, to delay the entire process.
Petitioner is directed to serve.
Krishna Lordship, expertise order passed against me. I am the wife.
Party
Order under section 9 of Hindu Marriage Act, Lordship. Passed against me, Lordship. In the annex in the page number 21. And our divorce case.
Yes, the decree. How revision lies.
This is an expertise order, Lordship, and
Expertise order revision lies.
Lordship, our
either you have to apply for setting aside.
set aside.
How can that be in revision? Or you can prefer an appeal. Either way, by the order.
Between the parties is still pending, Lordship. Code 98A.
That's neither here nor there. How can you challenge this in a civil revision application? That too, you are challenging an order of April 2024 in a civil revision application filed in 2026. This application under Article 227 of the Constitution. Yes.
But I'm for the opposite
this
party.
is my application.
May it serve as a copy, my lord.
Sir, what is this?
So this is my application challenging an order passed by the Honorable Learned Commercial Court, rejecting my application under Order 7 Rule 11 on the ground that it's a mixed question of law and fact. My lord, I have.
My lord, it has gone, the suit has gone to mediation. There is some time. If you may serve a copy and let us come back.
What is the rule 11?
I have pleadings to show is barred by limitation. It's expressly barred by limitation. I have pleadings to show from their own plaint itself. There is a time bar claim.
The petitioner is directed to serve.
In this matter, your lordship, I am appearing on behalf of the opposite party number 1, your lordship.
Yes.
Look, my application on the order 20 was 98 rejected. My lord, I was in position, decree was not passed against me. There was a decree, my lord.
Miscellaneous case under Order 21, Rule 99.
No, your lordship, it's a miss case under order 101, your lordship.
It's an appellable order.
Yes, your lordship.
Deemed degree.
Yes, your lordship. Deemed decree.
Well, I tell your lordship, now the law laid down by the Supreme Court is to initially frame a maintainability point. Your lordship kindly sees the application, straight away my application for stay.
Whatever it is, now it's the application. Miscellaneous case is disposed of. If the miscellaneous case is disposed of, you have to prefer a appeal. It's a deemed degree.
Lordship.
By the order impugned. Yes. Yes, what is this matter?
Madam, Prosenjit Mukherjee's matter, his matter, my lord. Prosenjit Mukherjee. Matter is that, madam, 8 of the West Bengal land function, preemption.
Preemption, yes. What happened? Preemption?
Enter share has been sold. This is the issue.
Yes. What remains? Supreme Court decided, special bench decided. After that, what remains?
Sorry, I do not know actually which is one. I am not confirmed enough. So many matters, probably I have got the such judgment. That is the kind of the last website, madam. I don't know whether it is true or not. Last website order from the matter is pending, madam.
Matter is?
Pending, madam. I do not know, but I did not confirm. I got the website, madam.
Yes, give me.
Probably bench or not, by the entire share. About the larger bench.
Pawan Sureka. Pawan Sureka is on limitation, I think. This has not been disposed of.
As I yesterday, till yesterday, as I got last order,
Yes, Mr. Rocky. Entire share has not been decided by the larger bench. What remains after the Supreme Court's judgment, Chanarani, and that thereafter the special bench decided over by Justice Bose? What remains? And the language of Section 8 is clear.
I have not confirmed. As I got information, I have got the website.
Everything remains in to be decided in the special bench. In this matter, matters cannot be kept pending. Nobody knows. Not today, করে রাখুন দেখি। Ask Mr. Mukherjee to come.
One only action. Actually, if I got some other judgment by the
Bring the judgments on the prayer of the learned advocate for the petitioner. List this matter.
Lord 43, I am for the petitioner.
Yes.
Even number 4 petitioner.
Yes.
By the impugned order, the trial court rejected my application under Order 7, Rule 11D.
Order 7, Rule 11D.
D. Because when it appears that the suit, before the suit was instituted, the defendant number 2 died.
Yes.
That is why against the dead person, my lord, the application has been, no application has been filed because he has been given or 2 has been implemented in the suit itself. So, my lord, if the defendant number 2 is dead before the institution of the suit, then, my lord, the
but it has been said that the legal layer.
Legal layers, there is no legal layers because they have not filed any application to make a note that defendant number 2 died during the pendency of the suit. It's a peculiar thing, my lord. If the suit is filed.
But can it be a ground under Order 7, Rule 11? Because
11D.
Can it be a ground under Order 7, Rule 11?
11D.
Order 7, yes, D is barred by law
Yes.
on the basis of the statements made in the plaint.
No.
So it's not your case. Defense case cannot be looked into. As it is from the plaint, can it be said that it has to be rejected?
Well,
Because it is you who is producing documents saying that that person is dead.
No.
Cannot strictly come under Order 7, Rule 11D.
When you look to this, my lord, they have, my lord, filed the suit on 23rd May 2025 and defendant number 2 died on 14th January 2022. Had it been a fact that they have filed the defendant number.
Can it be, Mr. Rokhit, can it be under Order 7, Rule 11D? Because Order 7, Rule 11D says statements made in the plaint.
Yes.
So it is on the basis, you may be right that a dead person has been implemented, but that's on the basis of some document, some information you are producing before the court. That cannot be a ground under Order 7, Rule 11D. Please take up. It's from the statements made in the plaint you have to show that the suit is barred, not from extraneous matters.
Now, if they, my lord, intentionally, my lord, made the defendant number 4 party.
Does it come within these? Please see where the suit appears from the statement in the plaint to be barred by law.
Yes. But
From
it
the
appears,
plaint,
it appears
not from any other extraneous documents. What you are saying, you are producing the death certificate to show that one of the defendants or the plaintiff, whatever it might be, died prior to the filing of the suit.
number 2 died.
Yes, prior to the filing of the suit.
Yes.
Can it come under Order 7, Rule 11D? It might be the other ground, maintainability, other things, it's separate. Can it be under Order 7, Rule 11D? What is the reasoning of the trial judge?
Yes, can you look to this?
What is the reasoning?
Reasoning is, well, can you look to this? Order number 18 dated 15th,
plaintiff filed an application for expunging the name of the defendant two and another petition paying for defendant number one being the legal heir of the defendant number two. So defendant number one is there. He is the legal heir.
no, he is not legal heirs. He is not legal heirs.
But the court records that.
Court records that
Petitioner is directed.
my lord, is my lord knows after the Supreme Court judgment, if the entire amount in preemption case is deposited, then my lord, the suit cannot, the application for preemption cannot be allowed. And they have filed an application amendment of the application for preemption. Preemption.
Oh, deposit further amount.
Further amount.
So that has been allowed.
That has been allowed. That is the question, ma'am.
No, this is the amendment petition.
Yes, amendment of application for preemption.
That's beyond time. The issue that
my revisional application.
But may I make one prayer? Mr. Bhattacharya is there in the matter. But he is in some personal difficulty today and tomorrow. But I have read the minutes.
Mr. Bhattacharya.
Mr. Rudraman Bhattacharya. But I have read the minutes of the learned arbitrator. A last chance has been given, so it is not proper for us to pray for an adjournment. But if your lordship could keep it on one
matter has been fixed.
26th, it has been fixed. But it is not proper for us to pray for an adjournment. But still, since Mr. Bhattacharya is there, if your lordship could keep it on Monday.
What is this matter? Let me hear Mr. Chaudhary once.
Very good, very good.
What is this matter?
Family arbitration in respect of a partnership firm. Partnership under a family settlement. My learned friends, clients will not retired from the partnership firm and will not be continued for 4-5 years. Then we converted the firm into a company. After 10 years, they come back and say, I am a partner of this firm. So, Milord, we say that under the family settlement, you've got your due. Why are you coming and asking for this? And in any case, you've retired from the firm and the firm is no longer in existence. It's become a company now. And under Companies Act on conversion, assets of firm vest in the company. So this was the situation. Milord, we did trial for around a year and a half. Witnesses examined. When it started, my Lord Justice Bhaskar Bhattacharya was the arbitrator. His Lordship said, preliminary point I want to frame. We went and argued for 1 day. End of the day, we said, let us settle the matter. Now both parties attempted to settle. We informally reached the settlement. That to be, Milord, written down. Learned arbitrator, Milord, has this notion that his Lordship will never take an extension under section 29. Never has it happened.
The mandate is going to expire.
No, mandate was about to expire.
Yes.
So went and told his Lordship that we'll take an extension. Lordship said, nothing doing. I will not allow any extension. Start arguing. So in 1 or 2 days, we kept asking for adjournment, hoping matter will be finally settled. Document would be done. It wasn't possible. In one day.
Now the settlement has
Good,
not,
my lord. Award passed.
oh,
One
award
day-
passed.
One day at 1:15, we were told, I went and asked for an adjournment on video call. And his lordship said that, no, what do you have to say? I said, I have nothing to say, I can't say anything. His lordship held against us. Past preliminary award, holding that his client's resignation from the firm some 10 years ago is bad in law. Now, my lord, 3 points emerge. Number one, I've challenged that by filing a 34.
Yes.
In the 34, I filed a 36 for stay because there is a direction for appointment of accounts commissioner. I have three, my lord, arguments. Number one, right to make oral submission is an inherent right. I've got judgments in our judicial system. So without hearing oral submission, the learned arbitrator deciding the matter on his lordship's own, my lord, knowledge of law and facts.
So that will be decided in 34.
Yes, but let the 34 be heard. What is happening is he wants to execute the 36 and proceed. Hey, execute the preliminary award and proceed. I filed a 34. His, my lord, learned arbitrator has directed accounts commissioner to go into accounts of a non-existent firm. This is the situation. I paid for stay.
Where is the order?
Now, please see the order issued. Stay was rejected. Kindly see, my lord, after page 136.
This matter was considered by other bench.
Yes, no, we had come up earlier at interim stage. So,
No, so many flag marks, that is what I am asking. This matter was considered by any bench.
no,
Flag marks.
previous round.
No, this round, this is the civil division application. See these flag marks. ফ্ল্যাগ মার্ক গুলো কোথা থেকে এলো? ফাইল দিলেন তো?
Judicial interns.
হ্যাঁ হ্যাঁ সেটা তো ব্যাপার। তো ফ্ল্যাগ মার্ক কোথা থেকে দিল?
Filed a flag mark to show annexure, maybe that.
Oh.
That is possible.
Oh yes, yes, yes. That might be
They
because
must have not taken it off.
on all the annexures, I think there is a flag mark. Yes, where is the
On annexures, you pay court fee.
yes? Where is the order? Impugned order.
Right at the volume 1.
Volume 1.
Volume 1, below that. Yeah. Three reasons given by the learned judge. Number one is that there cannot be stay under section 36 of arbitration is on limited ground.
What is the date of the impugned order?
Lord, it is dated 7th of August 2026.
Yes.
Lord, please come to the last page of the order.
Yes.
In view of the above, it is found that parties were given opportunity of hearing. After that, our order impugned was passed. Therefore, on the ground of without being given opportunity, petitioner should not get stay. Is not correct, then court is also agreeable to submission of Mr. Bhattacharya that according to proviso of 36(3), order for unconditional stay can be passed where court is of prima facie view that leaking of an award or the arbitration agreement has to be induced by fraud or corruption. Both grounds are Miller wrong. Because number one, that is only in respect of money awards. But we see the
This is section 36 application.
36 of Miller, the Arbitration Act for stay. But please see Miller. The proviso of section 36 is for money decree. The learned judge, my lord, has been pleased to apply that to this case, which is, my lord, not a money decree. Please see that paragraph. Total, my lord, mistake. Now, please see, prima facie view that award or arbitration agreement has to be induced or affected by fraud or corruption. Because that's in case of money decree. Money decree can be unconditionally stayed under proviso of section 36 only if it's by fraud or corruption. But this is not money decree.
Yes.
Now, Lord, the interim award says accounts commissioner has to be appointed and you must go into accounts of a non-existent firm. It will be infructuous if Milord matter proceeds. And the learned arbitrator has Milord kindly agreed to Milord all adjournments I have asked for because of pendency of this matter. Matter is kept, I think, on Monday. My copy আছে?
26.
Wednesday.
That is why, my lord, I was beseeching your lordship, it could be taken up on Monday, but Mr. Bhattacharya will also be there.
No, Monday, Tuesday, all matters have been fixed. I do not know.
Correct time now.
Monday,
Balcony.
fixed. Monday, Tuesday, I think both days. Tomorrow also.
Lord, heavens will not fall. My learned friend, Lord, should agree. You will not proceeding before the learned arbitrator.
Well, I do not have that instruction, my lord. I can't because the arbitration is being opposed tooth and nail.
Milord,
Tooth and nail is being opposed, my lord.
we have a different relationship. I have said in this section 34, let the award be set aside and send us back to his lordship. I have no problem going back and arguing the matter on merits. I have no problem. I know I will get justice. Everybody has always got justice from his lordship. Only thing is lordship's Lord notions your lordship knows when he makes up his mind about something. I will not take any extension. This is his lordship's thought. Every other learned arbitrator takes extensions under 29A. Whole problem is caused by this.
সোমবার কি অবস্থা বলুন তো? তা হয়ে যাবে তার মধ্যে? Because Monday, Tuesday, and both days from 3 p.m. matters are fixed.
But if before that, my lord, any time could, or my lord, if the matter is listed when anything.
Thursday.
Wednesday it can be done.
Wednesday is the sitting. If your lordship keeps it when the
Wednesday. Wednesday is a holiday.
It's been declared. There's a notification.
Okay.
Declared?
Yes. We got a notification.
শুক্রবার পর্যন্ত তো হবে না তার আগে
They should agree to take one extension.
But I don't have that instruction, and my lord, they are opposing the 29A also. My lord, we have applied for extension of the mandate, which the petitioner.
I'm keeping it on Tuesday. Let me see what happens. মঙ্গলবার?
Tuesday I was hoping Milord to.
কোনটা?
Monday Milord is not possible.
কিশোর দত্ত আর অনিরুদ্ধ চ্যাটার্জি যেটা আছে।
Maybe come back Monday at 4 o'clock or something, 4:15.
4 o'clock. 4 o'clock.
On Monday. Grateful.
Mr. Chaudhary, learned advocate.
I was hoping it will get called on.
Yes, you mentioned it yesterday. I told you that it can be taken up in course of this week.